Hey guys, how is everybody? Happy Saturday, or whatever day it is if you're watching this on Replay Crew. We got to start off with a shout out to some guy with cancer. It is his birthday, so if you see him in the building, make sure you wish him a good one. Hope everybody is doing well, whatever you're doing today. Here, we're going to be looking at the rest of what's available for the post-conviction relief petition docket for Zachary Adams. So we finished off March. There was a lot going on in March. We had some spicy motions and responses from both sides. One of my favorite things in the world now is Doug Bates used a header in one of his motions that just said, "What is going on?" And I just love it. So we're going to be starting off with April. I would actually love if, before losing my voice on the stream, we can get all the way through to what was available. So we're gonna get into it. We're gonna see tomorrow, you guys. I really want to rewatch Doug Bates' opening from the post-conviction relief hearing. I think it'll be a nice way to kick off the hearing on Monday and Tuesday, recenter us, since those hearings have been spread across a wide span of time, and also look at some of the sidebar transcripts. I may or may not do a stream later this evening where we look at a comptroller audit with civil forfeiture issues for the year 2010 in this same judicial district. And that would, obviously be the climate around the time of the abduction. So we'll have to play that by ear. Other than that, hey, it's Ariel. Became a member. Thank you. Yes, I got the desk completed. Although I got a new boom arm for my mic, and I don't have the the correct adapter for this particular boom arm. So I wish, I don't know, maybe I can kind of show you. It's not really attached to the arm yet. It's just kind of suspended around it. So if you see my mic collapse today or like the next few days before I order one, it's because it's not really actually attached. It's just kind of doohickied on here. So, but the desk is good. The desk is good. Ariel says, I want to be Doug when I grow up. For real, me too. I wonder if every Doug says that. Like, oh, I want to be just like Doug Bates II when I grow up. Or I want to be like Doug Bates III when I grow up. Or if there's going to be another Doug, I want to be Doug Bates IV when I grow up. Very cool to have that kind of family mentorship. Hey, DeBeezy, good to see you. I feel like I spent all night with you. Guys, Take It to Trial had Dana McClendon on last night. They did a deep dive into John Marshall Walker's testimony. So, he was not qualified as a cell phone expert at the 2017 trial, and then he testified at the post-conviction relief hearings. She was also rewatching some of that footage before he jumped on. The link to her channel is in the description of this video. So if you aren't already checking her out and did not see that, it was a great conversation. Great conversation. Max is ready to go. Hey to Gigi. Hey to DB. Shout out to Zachary Adams and Dog Bates. Hey, Christine. Hey, Factual Lie. We've got Trakeisha in the building. I spent a lot of time with Trakeisha last night as well, hanging out over at Take It to Trial. Got Nem in the building. We got AB. We got Janet Reed. Happy Saturday, everybody. Let's get through some of these. I think the first few are quick, short orders. So we should breeze through some, but inevitably there's going to be a 30-pager somewhere. All right, so we are on April 3rd of 2025. Isn't that crazy to be all the way caught up to 2025 as we're about to go into 2026? So we've got order of appointment to counsel to Jason Autry. The state said, hey, the defense wants to meet with Autry, but before you let that happen, even though he has counsel in another matter, we think you should appoint counsel for this particular matter, and that counsel needs to be there to advise him on his right to remain silent. So this matter came before the court on March 21st, 2025 for a hearing on various motions filed by the parties, including several motions related to petitioner co-defendants Jason Autry. Based upon the pleadings and information already in the record on Jason Autry's potential testimony in this proceeding, this court finds there are certain issues related to Mr. Autry's constitutional rights and his attorney/client privilege, with a footnote here that says petitioner has sought subpoenas for Mr. Autry's trial attorneys, Michael Scholl and Michael Flanagan, as well as his investigator, Clark Chapman. and then as well as potential consequences should Mr. Autry choose to testify. So this first part sounds like, violation of his right to attorney-client privilege and perhaps possible exposure on Fifth Amendment. But this second sounds like they're warning, issues with probation conditions, terms of his plea deal. Well, not probation, but terms of his plea deal. And then perjury issues, because that would be a risk. And do you think the state would be ready and primed to bring perjury charges against Jason Autry if he got up on the stand and said, I made up my 2017 trial testimony? Because I can see that happening. So, therefore, this court concludes it's necessary to appoint counsel to Mr. Autry for the limited purpose of advising Mr. Autry concerning these rights and potential consequences. So, Ben Harmon was appointed by this court, and then Harmon shall file notice with this court by April 11th, advising this court concerning Mr. Autry's decisions concerning both any potential testimony and or any waiver of his attorney-client privilege. So, there was that one, nice and quick. All right, next we have two more from April 3rd. Let's see. We've got order on the March 21st. So we're doing a bullet list. So the state's motion requesting the court to appoint counsel was denied as moot, because I guess they handled that with the previous thing. Petitioner's motion to conduct Zoom/in-person hearing with Jason Autry to determine if he waives attorney-client privilege is not ripe at this time, so they're going to wait to see what Ben Harmon says. Petitioner's motion to set expedited hearing via Zoom on pre-hearing matters before March 21st, denied as moot, because they had that hearing that they were meeting on this day. It would have been too late. Petitioner's motion for a court order approving communication with Autry is granted to the extent that Mr. Autry's counsel, Ben Harmon, is informed and to the extent that Mr. Autry is compliant. So that's kind of like if they want to. Petitioner's motion for amended writ of habeas corpus ad testificandum and to compel the state of Tennessee is not ripe at this time. Petitioner's renewed motion to subpoena and depose if necessary and schedule testimony from attorneys and private investigators is not ripe as to Mr. Autry's trial counsel and investigator. The motion is granted as to ADA Paul Hagerman, and the court directed Attorney Bates to issue any necessary subpoena. If opposition to the subpoena is filed, the court will act accordingly. All right. Several motions. We're going to have subparagraphs for the stuff addressing Katie Spirko. So the issues involving arguments about Katie Spirko, those were some of the 20, 30 pagers yesterday that we looked at. So several motions were filed related to the representation of Dr. Katie Spirko. The court granted the motion for substitution of counsel for Dr. Spirko. While it initially appeared that the state had some opposition to the substitution of counsel for Spirko, the state represented at the hearing there was no opposition to the substitution of counsel. So they just gave up on griping. The court directed Attorney Turin to submit the appropriate order. The court heard from the parties concerning the supplemental motion for substitution of counsel and declaration of Dana McClendon III. The court informed Attorney McClendon that collateral matters he wished to raise were not before this court, and the request for substitution of counsel had been granted. The state's motion to clarify record relative to representation of Katie Spirko was denied as moot. So maybe they answered that in court, or the judge just said, what she said is what she said. The court next addressed the issue of compliance with subpoenas. The parties represented that Attorney Jim Simmons had complied with his subpoena. The court then heard the motion to quash subpoena and objection to subpoena of Jennifer Thompson and Jerry Gonzalez. Now remember, this motion to quash was largely related to the expansive nature of the request. It wasn't quite a, hey, we don't want to respond at all. It was, hey, you want all of our computer systems, but we work on other cases on those devices, and it would take us a long time to separate it just to provide you what pertains to this. The parties addressed the issues with the court, and the state agreed to submit a separate order on the motion to quash by attorneys Thompson and Gonzalez, so probably some type of narrowing of scope. Next, the court heard arguments on the motion to quash Dr. Katie Spirko's subpoena, filed by both Attorney Turin on behalf of Dr. Spirko and by petitioner. The court finds that these motions are not ripe at this time. The court orders that no compliance is required unless later ordered by the court. Next, this court addressed several discovery-related issues. And this is like, to me, this is a big L for the state. They spent so much time. They wrote so much screaming and kicking and flailing about Katie Spirko. And the judge is just like, no. Just no. Next, this court addressed several discovery-related issues filed by petitioner. Relative to petitioner's motion to determine validity of the state's Discovery Rule 16 obligations, the court ordered the state to file a notice pursuant to Johnson v. State, upon compliance with the discovery obligations as set forth in the Johnson opinion. Oh, wait, what? Okay, upon compliance with, okay. All right. The court took petitioner's motion to compel the state to comply with Rule 28, Section 5G under advisement. After careful consideration, the state is ordered to file the requested information as it relates to paragraphs 35A and 35B of the second amended petition as requested by counsel at the hearing. Now, I think that might have been... Was that all the ATM stuff? Let me pull that up and let's look. Second amended petition. Oh no, it looks like it's further down. Oh no, it is. Okay. So 35 was upon information and belief. The petitioner was captured on an ATM recorder the morning of the victim's abduction. And 36 says, we respectfully request this court. Oh. No, they said A and B, right? Just 35 A and B, not 36. So there we go. That's what they want. And then relative to petitioners, so all of that, like, Amy Wyrick's whole, oh, subterfuge. Oh, these ATMs, they had everything. The court's like, go make sure. Go make sure. Relative to petitioner's motion to show good cause to release the investigative subpoena and affidavit under 40-17-123 and petitioner's motion to compel production of photos and videos. The state indicated that there was no affidavit, but agreed to provide the investigative subpoena to petitioner, so that where they opened up a new file, went to the bank manager and said, hey, don't tell anybody about this subpoena. Keep it hush-hush. They're going to provide that affidavit. And then as to the photos and videos, the state indicated it had provided the information to petitioner's counsel, and if there was any issue in gaining access, it would be provided again. The court lastly addressed the state's motion regarding information filed under seal by the trial court. The court denied this motion and advised the state to file a more particularized motion. Yeah. The state wanted everything. They want to open everything, see everything, even if it would be attorney-client privilege. And this court said, do your job. Tell us with particularity what you want. So Bradbury just knocked out a bunch of orders with this bullet point list here. And then there was one more filing for the 3rd. Okay, and this one's going to be about Dylan Adams. So order on the motion for writ of appearance for Dylan Adams. So let's see, it's not ripe for disposition. So as of the hearing date, neither the state nor counsel for co-defendant John Dylan Adams had filed a response to the motion. In addition, counsel for John Dylan Adams was not present. So it's not ripe. And then they say by April 11th, counsel for John Dylan Adams shall file any opposition. So giving them a little bit more time. All right, and then we're going to be moving on to middle of April. Remember, as we get towards the 19th down here, that's when we're going to have, like, this stuff will be before we saw any of the hearings. But this would start, these filings would be coming in after, like, the opening statements from all of these proceedings. So that's going to be cool to see. Notice of intent for Jason Autry. We've got April 11th. This matter was heard at the March 21st hearing regarding the state's motion to appoint legal counsel. Pursuant to the court's order, Benjamin S. Harmon was appointed as counsel for Autry to advise him on his constitutional rights and attorney-client privilege. The court further directed counsel to file a notice of intent by April 11th, indicating whether Mr. Autry intends to assert his constitutional rights and whether he intends to waive attorney-client privilege. So counsel consulted with Autry by phone due to technical difficulties with the originally scheduled video conference. A video conference has been rescheduled for April 16th. At this time, Autry intends to assert all protections afforded to him under the United States Constitution and Tennessee Constitution. 2. Decline to waive attorney-client privilege regarding any requested information related to his former attorney and agents. If Mr. Autry's position changes on any of these matters, counsel will promptly notify the court by filing an amended notice. So, state got what they wanted here. State got what they wanted here. We've got motion granting the order to withdraw. That's probably going to be Katie Spirko stuff. Yeah, so Dana McClendon he can withdraw, and Kaylee Turn's going to substitute as counsel for Katie Spirko. Present before the court were all counsel of record and Zach Adams. In opposition to this motion, the state had filed a motion to clarify the record. The court heard the statements of Mr. McClendon and Mrs. Wyrick for the state. After reviewing the motion and the declaration filed by McClendon, the court finds the motion to have merit. Mr. McClendon's motion to withdraw and substitute Kaylee Turn as counsel for Dr. Katie Spirko is granted. Mr. McClendon is relieved as counsel for Dr. Spirko, and Kaylee Turn is recorded as counsel for Spirko. So then we've got another notice. It just says notice. Okay, this is Amanda Gentry for Dylan Adams. So she says she doesn't have an opposition. She doesn't object to John Dylan Adams being transported for the purpose of testifying. So, and then Gentry does not object to John Dylan Adams' participation in the proceedings regarding Zach Adams, nor to the testimony of John Dylan Adams without counsel present in the proceedings. Oh, okay. Well, I mean, to me that seems like Amanda Gentry might think her client's innocent, but maybe still be worried about exposure. And remember, you guys, John Dylan Adams, Zachary's brother, he accepted an Alford plea after Zachary Adams' trial. And he was sentenced, I think 36 years was the sentence to serve. So he maintained his innocence, but acknowledged that if he went to trial, there was a good chance that with what the state would present, a jury would convict him. All right, guys, and we finished April. We made it to May. So we're moving right along. Yeah, I see, checking over at the chat to see what you guys are talking about. You got warm weather. It's 70 here right now. So quite warm. Quite warm. AV says, can't say that I miss the snow. I miss a good New York apple. Like, I'll think I have a nice crispy apple, buy it from the store, try to eat it the same day, and it's mushy. It's like mealy. It's gross. There is nothing like a good New York apple. So I miss that. I'm with you on the snow. DB has a nice crisp 35. Aw, hey Janice. So the new desk is nice. It's, you know, my monitors, I don't feel like I'm knocking into them. I got like arm's length here. So I'm really excited about that. It's a bit shorter. So I got to make sure I don't like, sometimes I pop my leg up and put my arm on my knee. Got to make sure I don't do that. So again, if you see me knocking around, it's just me adjusting to my surroundings. Good to see you, Janice. Oh, ooh, Fun Size says it's going to be 80 in Oklahoma. 80, oh, that's a little high for December. That is crazy. Lynn's got some cold weather, some 7 inches of snow. That does probably look really pretty. We've got, no, I did not add honey. I've been up for a while, you guys. So long story short, I think my whole apartment wants to do the New Year, New Me, right? The desk was my choice, right? But last night, my washing machine wouldn't drain. So as soon as I'm done with this, last night I was wringing out my clothes to get them in the dryer. But today I've got to wet vac the water out and then try to see if there's a sock caught in the drain and hope that that's all that's wrong with it. So I've been up for a while. No honey. I'm on to soda, already done with my coffee. But probably should add that into the mix tomorrow. And then I saw Amy E here in the building. I'm trying to scroll up to find her. Hey, Amy E. Good morning. Good morning. If you guys don't already know, Amy E has a channel where she does archives of like arrest, body cam footage, all of the stuff that you have to request, and it can be a pain in the butt. She does all the hard work. And she's got a ton of stuff you can go back and watch. Wanted to say hey to J Money and to Gwennon popping in. And sorry if I'm missing anybody. We got right into these motions here. Because we've got... I know one of them's going to be long. Eventually we're going to get to one that's going to be like a 30-pager. We're just going to be like, oh, here we go. So I just wanted to make sure we can move it along and be ready for these Monday and Tuesday hearings. Those are going to be like 12-hour streams, guys. We are going to watch the full hearing, and we're going to have some guests pop in, maybe even before, but probably after those sessions. So I'm gearing up for 2 very long, but days that I cannot wait for. Like when I say a long day, it's like when you're a kid and your parents are like, we're going to the theme park. Like the parents have to gear up maybe. It's going to take a toll on them. But the kid is high energy. The kid's ready to go. So that's how I feel about Monday and Tuesday. But I do want to make sure we get all of this. We have all of the backing context possible. So getting into May, we've got motion for leave. Oh, okay, so this is where we want to add, I think we looked at this as a 30-pager, you guys. I think we talked about this during, like, one of the first few days we were looking at this case. We'd gone and we were trying to look for the orders in relation to the motions in limine we heard discussed at the May hearings. And we saw they were able to amend the petition to add in this hot mess about things like the ATM video. So let's read this in full because I think we've only kind of like briefly talked about it. So again, this is May 2nd. This is the petitioner's proposed addition to the second amended and supplemental petition for post-conviction relief. So comes now the petitioner Zachary Adams, by and through his undersigned counsel and pursuant to Tennessee Code Annotated 40-30-101, respectfully submits this proposed addition to the petition. Petitioner moves this court to consider the newly discovered evidence, constitutional violations, and legal arguments set forth below in support of his request for relief. So they're going to incorporate everything else that was already in the petition. The original petition, the pro se filing, and then the second amended petition filed by Det Bates. So we've got United States and Tennessee constitutional violations revealed by ATM video showing petitioner at Community South Bank in Parsons at 11:12 a.m. on April 13th, 2011. So contrary to the testimonial evidence fabricated by the state's witnesses whose lives and liberties were threatened until they adopted a narrative presented by the state to justify a conviction against Zach Adams. That is a sentence. Let's run that back. Contrary to the testimonial evidence fabricated by the state's witnesses whose lives and liberties were threatened until they adopted a narrative presented by the state to justify a conviction against Zach Adams, there is one undisputed piece of physical evidence of the petitioner, Mr. Adams, exact, with a footnote. We'll finish the sentence. With the exact whereabouts at a time certain on the morning of April 13th, 2011, a video from an ATM. So this footnote says Mr. Reeves at trial adequately detailed Mr. Adams' whereabouts in relation to cell phone tower coverage, but nothing like the video that shows Mr. Adams' exact whereabouts at the relevant time. Moreover, the ATM video refutes the state's far-fetched theory that the defendants were not with their cell phones, despite the cell phones being in use throughout the time period in question. And this second part is really what's important, because the state at trial argued, well, even if Mr. Reeves is right about all this, it only would show you where the device is. And he was spoofing, and Rebecca Earp said that she thought she was getting a call from Dylan, but it was really Zach's phone. So the jury, if they were so inflamed by everything else that they were hearing, these pink panties, we know it was these guys, Autry told us we fired the shot and boom, boom, boom. Well, the jury might be inclined to just disregard anything about the phones being in Parsons as having anything to do with exonerating. And that would also mean that the jury had to digest the time frames. And personally, it's taken me a long time to understand the movements between about 8:30 in the morning and 11:12 when they're supposed to be at this ATM. And understand the state's theory of where everybody was, Jason Autry's story of where everybody was, and then what actually is shown by the data. So I'm not sure if I expect the jury to have understood in one swoop through the trial why what Mr. Reeves was saying was significant. So back up to this fire of a paragraph up here. This video has a history in this case shrouded in obfuscation and deceit, not the least of which was the state's refusal to produce it until the night before it was to be called to account in open court. This video destroys the state's timeline at trial, corroborates the veracity of the cell phone data presented at trial by testifying expert Mr. Reeves that Mr. Adams was not traveling back roads with the remains of Miss Holly Bobo, and reveals the depths that the state has been and is willing still to go to get and preserve a conviction, any conviction, in this case. For real, this is, yes. This is, doesn't this, like, I can, like, feel why, like, our first experience with Doug was when we're like, oh, what's going on? And we went and watched the May, we're like, oh, there's sessions in May. Why does this go so far back? Okay, they have, like, a magnet board. That's cool. And then all of a sudden, Doug's like, no, wait, this is delicious. And he starts laying this out. And I knew it was something crazy just by how he was delivering it. But now reading it, after having the time to process all the details, the 18 months that Doug has spent unraveling and figuring out exactly how far the state and its agencies have gone to try to get and keep a conviction in this case, this is just a pleasure to read. So petitioner brings to this court's attention newly reviewed video evidence from then Community South Bank, now CB&S, in Parsons, Tennessee, timestamped at 11:12 a.m. on April 13th, 2011. This video directly contradicts the state's timeline presented at trial and supports both the cell tower location data introduced by defense expert Mr. Reeves and the multiple reports provided to law enforcement by Zach Adams and his co-defendants regarding their whereabouts and activities on the day in question. So then that's the thing, like, they had been trying to tell law enforcement, like, they thought they were just riding around. They thought they went and got corn dogs at Sonic, or I don't know what they got at Sonic, but that's what they're known for, right? Shakes and corn dogs. It establishes that petitioner, and tater tots. It establishes that petitioner was not engaged in the abduction or transport of Holly Bobo at the time alleged, and was in fact documented on surveillance video at a location inconsistent with the state's theory. A careful review of the state's own investigatory records reveals their nefarious intentions. All right, so we've got Investigative Report 1845. On September 20th, 2013, the TBI listed CDs, DVDs, and flash drives containing digital media obtained during the course of this investigation. All the below will remain stored at the Jackson TBI office. So, this is all the way back. The year of the abduction, September 20th. Part of these data were in folders labeled video and included labels V1, V2, etc. I think this one's under V8 or something. V3, 4 were simply labeled BP, April 2011. V4 was labeled BP at I-40, April 2011. V7 was BP Highway 412. Oh, Highway 412, that's the highway number. On April 3rd, 11. And I hate that these schematics, like, they're not using a consistent naming schematic. And that would mean if you're trying to find everything from April, you'd have to be aware that you would want to try to search an exact match phrase for April space 2011. Or maybe 4 to the slash. And who knows how else. There could be other ways, like APR, period. And that just makes it harder to do a search and find everything that would be from April of that year. So, V7 was BP Highway 412, 41311. V8 was labeled BP/Com South Bank ATM - April 2011. All right, so eventually this investigative report was provided in digital evidence, and V8 had become only BP. So this is where they renamed the file. So they had this IR that listed it all out. So whoever prepared this investigative report, and now I want to know if I notated that for Terry Dykes. Whoever prepared investigative report 1845 in September of 2013 listed the contemporaneous names of these files. And at the time, this ATM video said ComSouth Bank ATM, which if you're scanning file names, you might go, oh my God, there's an ATM video. But in the folder that Jennifer Thompson had and what Doug Bates was relayed when he took on this case, this file name was now only BP. Not BP ATM, not BP/ComSouth Bank, just BP. Which I'm pretty sure that's like a gas station convenience store. So would you look at this and think it was going to be that ATM video you were looking for? Why would you change this file name? Were any of these file names changed? And I love seeing this on paper because we heard this argued, was it with Kathy Ferguson? We heard Doug asking questions about this. I think the most in-depth with Kathy Ferguson when she was on the stand. But seeing it spelled out, you know, it's not like someone is just misspeaking when they're speaking out loud. I mix up my words when I speak with you guys. But seeing it just in quotes, and the whole quote here is BP, is nuts. So was it said that it was a TBI intern that mislabeled the BP video? I don't really remember the excuse, but I remember it being like, it was not intentional. To quote Sarah Boone. Yeah. KLB says, I would think it was a picture of a tomato cocktail. Oh my goodness. So this is critical. And this is giving Doug, this is why he's able to amend this, is not only are they finally getting through this whole subpoena gate, and now there's this affidavit that they can introduce of how the state tried to surreptitiously run and get the ATM device before Keedy Spirko and company were able to get it. And then telling the manager, don't tell them we came to get it. So then Doug has to find out that they went and got it. But now they get to bring in all of this, like, hey, this stuff was renamed. Like, this together, cumulatively, paints a picture of nefarious conduct. And not just, like, someone hiding something, but someone hiding something that completely would alibi somebody at trial if the jury was able to see it laid out. Yeah, that's a good way to put it. So Max Freeze says, they just all said it was not me, as I recall it. Yep. Nobody was accountable for anything. Nothing. So Doug's going to describe this and Crystal, saying, leading one to assume the bank ATM files were missing. Thus, the long-standing effort on the part of the petitioner by and through counsel to acquire and review the ATM bank footage. It was in these incorrectly labeled files where the ATM bank footage was stored in file formats petitioner's trial counsel was unable to open. And remember, she was using like Apple devices. Search warrant. And if you missed it yesterday, we went through the state's argument on some of this stuff before they had to turn over the affidavit, right? So we saw their argument before that March 21st hearing where now they have to turn over the actual affidavit. But they were arguing against any issues relating to this ATM. They're like, no, it's fine. All you had to do was go through these 9 steps, then install a software, and then go find the directory pathway through the software to open the file. It's fine. Anybody could find it. Anybody would know that ATM video was there. And you'd only have to know to look for it under the title BP because it was no longer going to be named BP/ComSouth Bank ATM. Someone changed the name. Just no big deal. No big deal. So that's what what Doug means when he says it was in these incorrectly labeled files. You had to find your way all the way there. So, search warrant. A search warrant was issued on September 22nd, 2014 for the 2006 Chevrolet Silverado that belonged to John Dylan Adams. Now, I love this because so many of us here, I see some familiar names, watch the YSL trial together. And they will put up a blurry, pixelated, like middle of the night sepia tone surveillance picture from far away. And they'll be like, can you see what car that is? And they're like, yeah, well, that one has a certain shape of a license plate light, so I know it's this exact make and model. Like, what? What? And here, in this case, with what I think is a better quality image, where you can see some of the decals, you know, different trucks have the molding and the decals and the little nuanced designs. You can clearly see all of those things. And the state doesn't even want to say it's a Chevy. The state doesn't want to say it's a Silverado. The state will absolutely not say it's a 2006 Chevy Silverado. Even though they seized the car. So they had like a close-up look at the exact same vehicle that they could have compared this picture to. And they're just going, oh my God, no. So September 22nd, 2014, a search warrant was issued for the 2006 Chevy Silverado. So this would have been after, guys, remember the timeline. This is after we have a new sheriff and we have Matt Stowe take office. So we have Keith Bird, the sheriff, and then Deputy District Attorney General, whatever the Tennessee title is, for the 24th Judicial District, take office on September 1st, 2014. On the 7th, Holly's skull is found by the ginseng hunters. And then for the next 2 days, there's like Jeff Jackson and Brent Booth are like poking around by themselves at the scene. And then 2 days later, we're getting the line walking where like the whole community and the forensic people are out there walking arm in arm every inch looking for evidence. And then on September 17th, 10 days after the skull is found, Dennis Benjamin walks John Dylan Adams, who's been living with him for 5 weeks as a probation condition, into TBI and says, I've got it. He told us everything. I've got the confession. I've cracked the case. So that was the 17th. And that's when we have that interview with Jeff Jackson yelling details and answers at Dylan. September 22nd. So 5 days after that interview, they issue a search warrant for the Chevy Silverado. Agent Joe Walker of the TBI provided an affidavit and stated the vehicle was being held by the Decatur County Sheriff's Department. Per the affidavit, Agent Walker was relying on Dylan Adams' statement, subsequently proven completely false. He said that they were like raping her in a basement in this interview. None of these houses have a basement. Also, while I'm yelling at the screen, I see that some guy with cancer's in the building. Happy birthday. I hope you are having a great birthday. So he says, I'm an expert because I pass them in traffic. And you guys all remember the Infinity expert. The chat knows. The chat remembers YSL. I'm an expert because I own one. Oh, good times. Shout out to Take It to Trial. You did a long day yesterday streaming and great interview. I told everybody to go check it out. I'm going to tell them again, guys. So Take It to Trials. Go on her live video tab, the most recent one, unless you're live this morning. You will see Zach Adams. You'll see a little picture of Dana in the corner. Go check that out. Did a lot of rewatches of the trial and the post-conviction testimony and had Dana on to answer a ton of great questions. So that was really awesome. Take It to Trial. Hope you're having a good Saturday. Loving these birthday wishes here in the chat. And we've got, let's see, back to this search warrant. And look, do you guys feel like we have a good grasp of the timeline? Like this month of deep diving has been worth it because I have the dates. Like it makes sense to me. I can picture the timeline of events. And now that I understand the timeline of events, the more gross, the more disgusting it looks to me what the state did in their effort to get justice for Holly Bobo. So they get this search warrant. It was relying on Dylan Adams' statement. Joe Walker was asked about this. Like, do you still feel confident? And he didn't really want to say he wasn't confident in it anymore. Which was subsequently proven false, that between 9:35 and 10 in the morning, Zachary Adams and Jason Wayne Autry were at 256 Adams Lane in the Silverado with Holly Lynn Bobo. So this goes against, this is not how the story would have fit for Jason Autry's testimony. Then, according to this false confession, Dylan Adams, Zach Adams, and Jason Autry all had forcible sex. And we know this is not Jason Autry's testimony, because he did nothing. He didn't even know it was Holly in the blanket. All had forcible sex with the victim. Dylan purportedly doing so at gunpoint at the behest of his brother. And the rumor here was this might have been a detail meant to line up with what was going on with the Piercy brothers, where someone came forward and said that there was some video where Holly was on video at the Adams with Zach Adams being made to have sex. And that this might have been involved. So that's my theory on why Dylan Adams was given this detail. I think TBI got it from what they heard in the rumor mill with the Piercy brothers, who we looked at that timeline. That was another bizarre timeline of like sort of charging somebody and then dropping the charges in a convenient timeline. So then, per the affidavit and Dylan's so-called confession, between 1 and 2 hours later, Zachary Adams and Jason Wayne Autry exited Zachary Adams' bedroom, physically supporting Holly Lynn Bobo. So apparently they're doing this for at least an hour and up to 2 hours. And then there's commentary. This narrative not... Doug says, hold on, we're going to add some commentary. This narrative not only contradicts Jason Autry's testimony, but more importantly, it is impossible to be true based on the following. 1. Cell phone activity of the co-defendants is irreconcilable with the narrative. 2. Video footage of the defendants and Dylan's truck at the ATM and elsewhere in Parsons reveals them to be elsewhere at the time. 3. TBI performed an exhaustive search of the petitioner's home after Dylan Adams reported observing a large amount of blood on the floor and furniture. Extensive scientific analysis performed by the TBI yielded no DNA or other physical evidence that Holly Bobo had ever been harmed or otherwise present in the home, also yielding no evidence of any attempt to clean or conceal such evidence. They tore up his floorboards. They looked about anything that they could. And remember, the news media was going off. They had all of this B-roll. They're excavating Zach Adams' backyard. There was a shallow grave. There was a dog hit. The cadaver unit got a hit. And then they found bones. That's what the public's hearing. From a narrow window of TBI Director Mark Gwynn on February 28th of 2014 saying, we've issued search warrants after like a 2.5-year lull in any major progress in this case. And then by March 5th, they're announcing the indictment, leading one to believe, hey, if you had search warrants and then you're indicting someone 5 days later, when we heard you find bones in the back of his yard, that must be why you're charging him, right? You obviously found physical evidence at her property. So I really think that when you have 97% of the potential jury pool in the county over saying they heard about news coverage of this case, you probably heard that they found physical evidence at Zachary Adams' home, even though it's completely untrue. No physical evidence. And not just no physical evidence found at Zachary's home, but there's no physical evidence whatsoever connecting what happened to Holly Bobo to Zach, Dylan, Shane, Jason. None. Anywhere. So here I am yelling at the screen again. Big thank you here to Take It to Trial. Very generously gifting 10 memberships. I saw all the thank yous in the chat and I was like, hold on, let me go look. So thank you guys for saying thank you because it put me on to see it right away. Big thank you here to Take It to Trial. Again, her channel link. If you hear me call her Sweet Pea, that is how she goes. That is her name I mean take it to trial. So anytime I use her name interchangeably, that's who I'm talking about. Make sure you're checking out her coverage. And in addition, if you're ever looking for other trials to watch, she's got a trial going all the time, whether it's a throwback or a fresh trial. And she is linked in the description, so grab that link at any time. And also, Gigi here dropped it. Thank you, Gigi. Thank you, Gigi. Yeah. And then we have Brent Booth saying, what do you mean evidence? What do you mean by evidence? Like, bro, you got an award for your service as TBI agent, and you're going to have to ask what evidence when Doug Bates asks you? Oh, my goodness. So yeah, they do this exhaustive search, and nothing reveals any tie to Holly Bobo or an attempt to hide or conceal evidence. Likewise, no physical evidence linking to Holly Bobo was discovered in Dylan Adams' truck, nor any vehicle owned or operated by Mr. Adams and his co-defendants, all of whom had their vehicles seized, searched, and forensically analyzed. I think this must have been seized. Oh, he's quoting! What is he quoting here? He is quoting here what we heard about the plea colloquy, the plea hearing for Jason Autry. These questions left open, in quotes, as the state's agent remarked, serve as a shaky foundation of fabrications and falsehoods upon which this entire investigation was built. In Investigative Report 2743, Agent Joe Walker issued a subpoena for the bank records of Shane Austin from CB&S Bank, Incorporated. Pursuant to the application, Agent Walker swore to the fact that, through his own statements, Shane Kyle Austin admits he was with Zachary Adams and John Dylan Adams on April 13, 2011. Agent Walker received the bank records and reported as follows. The transaction for April 13, 2011 were as follows. $120 from the ATM at Community South Bank, $22.02 from Shell Service Station in Holiday, Tennessee, $10 from MAPCO, store number 2012 in Parsons, $9.84 to Shell Service Station in Parsons, and $6.78 from Sonic Drive in Parsons. A check of video recordings from that date is to be done when a player is obtained for the MAPCO and a BP video from 641. The other places were not covered by our videos. And so they're adding emphasis on this line here. The TBI never advised of anything further on these videos, despite the fact multiple videos are exculpatory, particularly considering the corroborative bank records. So they ignored it. Well, that's why trial and error says TBI stands for truth becomes irrelevant. Despite its obvious significance, the ATM video, along with other security camera videos in the area, as we have recently become aware and intend to present. So I think one of these is when we had Dylan Adams on the stand. He shows, hey, that's me on the camera purchasing something. Was deliberately withheld or mislabeled during trial discovery. The state failed to provide usable access to defense counsel, and data from the DVD labeled BP Community South Bank ATM April 2011 were effectively hidden under inaccurate metadata. Only years later, and after extensive effort by petitioner's counsel, was the video's existence recovered and eventually disclosed. The state ultimately obtained the original device via investigative subpoena and did not alert defense counsel or co-defendants counsel within the timeline required by TCA 40-30-123. There's a footnote. The reason, quote, an ongoing criminal investigation, JA 90A number 5, perhaps the most troubling behavior yet from the state, though. The TBI provided to the person served the subpoena a document that read, "You are not to disclose the existence of this request. Any such disclosure could impede the investigation and therefore interfere with the enforcement of law." Now remember, they're running to do this in 2024 during these post-conviction proceedings, the day after they find out that Katie Spirko is about to obtain this stuff. But they use an ongoing criminal investigation to circumvent the need for a judicial subpoena. They have the power to go get one on their own under the guise of a criminal investigation. You know, maybe it's the type of criminal investigation that when we have this bolded here, where Joe Walker's like, other places weren't covered by the video. You should have been, that would have been when you were doing a criminal investigation. Years ago. Between 2011 and 2014. You suddenly said in an IR report that there were no videos from this CB&S bank. And I don't know, maybe their naming schematics are messed up, but they said this was Investigative Report 2743. Pretty sure here, Investigative Report 2473 would have been issued and documented after IR 1845, which is where we have this bullet point list where this video was still labeled as BPCom South Bank. And I know that's like very detailed, very complicated, but it's extremely telling. So you have an earlier investigative report that's aware of this video from Community South Bank. Then, hundreds of IRs later, you have somebody saying, hey, actually, this is what we were able to find. Yeah, there are some purchases, but we don't actually have video from this bank or other places. Later, and after the file name is changed. You can't convince me that that's not foul play. So, let's go back to where this was with this footnote. They say, Doug says, this conduct violates the state's constitutional obligations under Brady v. Maryland and its progeny. At trial, the following evidence was entered. A, Mr. Adams' cell phone was, quote, pinging off the Birdsong cell tower for parts of the morning. Based on Jason Autry's recanted statement, he and Mr. Adams were probably doing drugs together in that area. The route their cell phones, quote, pinged and time frames therein, as illustrated by Mr. Reeves, demonstrate they were traveling by interstate back to the Yellow Springs Road / Adams Lane property. See Exhibit 240. And I believe he's quoting, putting pings in quotes, because there's a difference between the type of phone pinging that they had for Holly's phone versus when, hey, your phone is connecting to this tower, and this is a circle of area that you're probably in. So the time frame and route Mr. Autry testified he and Mr. Adams had driven, namely the winding back road journey from under the Tennessee River I-40 bridge to the point at which Mr. Autry purportedly returned to his PT Cruiser. Because remember, he says he left this PT Cruiser parked at the church down the road from Shane Austin's. Would take approximately 32 minutes and require passage through the 39078 cell phone sector, where their phones never registered. He's bolding this. It says, it is impossible to reconcile Mr. Autry's testimony, and for that matter, Mr. Adams' involvement in this crime, with Mr. Adams and the co-defendant's cell phone records. They say, see generally Jason Autry's testimony and Exhibit 237 at trial. Mr. Adams' cell phone registered on the northeast 39077 cell tower at 10:32 a.m. Mr. Adams' cell phone registered on the northwest 39079 cell tower sector at 10:35 a.m., a mere 3 minutes later, entirely bypassing the south 39078 sector of the tower. Upon information and belief, over 3.5 miles of this alleged route would be covered under tower 39078 and would take, at best, 10 minutes to travel. Mr. Adams' cell phone then registers on his home tower and sector at 10:38 a.m., another 3 minutes later. This cell tower sector path in the observed time frame of Mr. Adams' cell phone on the morning of April 13th is only possible by interstate travel south to Parsons on I-40. And if you miss, and this would be a great time to go and watch Take It to Trial's interview with Dana yesterday, where they talked about U.S. Marshal John Walker's work. But what Marshal Walker did was different than just saying, like, all right, these phones were hitting off these towers at this point in time. He was using a different technology that was available to the feds at the time. He wasn't able to talk about it at the trial. But he also recreated the routes and spent, I think he said 3 months, taking the same devices that Holly's phone would have been using. And he did it with more than one device just to make sure, like, there wasn't an issue with the internal one make and model has a slight defect compared to another. He replicated everything. And through process of elimination, he drove the possible routes over and over and over and over to see what would ping on what towers where. So a bit more in-depth and kind of like tested compared to the generalized cell site, cell tower coverage maps presented during the trial. So we've got the Parsons ATM is approximately minutes away from Mr. Austin's home on Yellow Springs Road, passing through Mr. Adams' home at 256 Adams Lane, Holiday, Tennessee. Pursuant to a newly run and recklessly run route. So they're trying. They're like going as fast as they can. From the approximate location of the 10:32 a.m. cell tower to Mr. Austin's driveway, but not down it. So they skip doing what they would need to do. They don't even go into Austin's driveway. And to Mr. Adams' home, and then to the cell phone. It is absolutely impossible to make this route by 11:12 a.m., not taking into consideration a single second for stopping, dropping off, and picking up the various people. Thus, the commute time is already impossible without adding in the additional time necessary to carry out any of the activities as laid out in Mr. Autry's testimony. Mr. Adams was in his brother's 2006 Chevy Silverado at 11:12 a.m. with Mr. Austin and Dylan Adams. But wait, there's more. And that's part of the filing, that's not me. The state's narrative includes Mr. Adams putting his truck in Victor Dinsmore's garage/pole barn before the alleged meeting with Mr. Dinsmore in the early afternoon. In order for Mr. Adams to carry out this additional task before traveling with Shane Austin and Dylan Adams to the ATM, a couple gas stations, and Sonic, the following would have to be possible. Now, quick recap if you've missed any coverage about the Victor Dinsmore saga. There is a video on, and it might be linked in the description directly, that I did called Crafting a Conviction. And this is where we compare the trial testimony, or the PCR testimony of Dennis Benjamin, who initially is meeting with Dinsmore 2 different times. One of the trips is with Valerie Trout, TBI agent Valerie Trout, in February, March of 2014. Fast forward to 2017, after Jason Autry, star witness, gets his discovery file and 2 discs of files that are accessible that Jennifer Nichols, trial prosecutor, tells TBI agent Joe Walker, hey, I'm authorizing you to release these 2 discs just to Autry's attorney after the other defense counsel told me they can't access certain files. But the release was only to Jason Autry. So Jason Autry has information that the other parties don't have available to them to start prepping his story. He starts doing these proffer sessions. Even though he's too dangerous to transport to these post-conviction relief hearings, they have him driving around and running the route so he can say, hey, this is where we went next. And he has a proffer session in May with Jennifer Nichols. It's not documented until June, but he has the proffer session. And Jennifer Nichols and Brent Booth swear they're both unaware, they didn't communicate about what Jason Autry said in those proffer sessions. But suddenly after that proffer session, TBI agent Brent Booth is visiting Victor Dinsmore in Indianapolis and saying, hey, I need you to help me. And on the first day, Dinsmore is like, no, he didn't have that truck then. No, he never put anything in my pole barn. The next day, after being told over and over what Jason Autry is going to say at trial, and reminding Victor Dinsmore, you know, we already gave you an immunity agreement on certain things. We really need you to help us. Oh, that's helpful to me. Goes back the next day and says, hey, I wanted to make sure yesterday I wasn't putting words in your mouth. And suddenly Victor Dinsmore and his wife are reciting, yeah, we refreshed our memory and now we remember Zach did move rims out of the garage to put his truck in the pole barn that morning. So if you missed all that context, that's how we have Victor Dinsmore, quote unquote, corroborating the state's theory and what Jason Autry is going to testify to at trial. So this impossible route, where this route cannot be done in this time frame, even if you don't do all of these side quests, Doug is now saying, but wait, there's more. This timeline also needs to incorporate a key part of the state's theory. and Jason Autry's testimony and Dinsmore's testimony that they lined up. So apparently, Zach Adams needs to have put his truck in Dinsmore's garage before the alleged meeting later that afternoon with Dinsmore, with the "I hit it" quote. In order for Mr. Adams to carry out this additional task before traveling with Shane Austin and Dylan Adams to the ATM, a couple of gas stations, and Sonic, the following would have to be possible. Per Victor Dinsmore's trial testimony, Mr. Adams would have had to find additional time to take his Nissan truck and hide it in Victor Dinsmore's garage. First, talking with Victor's wife, Sandy, about it. And Sandy on these calls is like, I never went outside. I didn't go talk to anybody. Or actually, that was her testimony. Because during these calls, she was like, I don't remember it because I wasn't feeling good. I wasn't home. And Victor's like, yeah, I had to go get her from the hospital. She was in the hospital at the time. Then during her trial testimony, she came up with a way to actually be at home, but say she didn't go speak to anybody. She only peeked out to see who was there and saw the three guys. So, I think Jason Autry says during the 2017 trial that Zach tells him he spoke with Sandy that morning. So that's why they have to get this to line up. 2, given the absence of any physical evidence in the vehicle and its general condition, Mr. Adams would have had to extensively clean the Nissan and then reclutter it with his belongings and various debris. For reference, a photo of the pitiful condition of the Nissan truck when impounded and thoroughly tested will be submitted, and the court can draw its own conclusions about the cleaning capabilities of Mr. Zach Adams. Dang, taking a dig at your client. Mr. Adams stayed in Parsons until 12:35 p.m. that afternoon, per his cell phone activity. Mr. Dinsmore provided critical testimony regarding some key aspects of the state's narrative regarding the case. As aforementioned, Mr. Dinsmore testified that Zach Adams parked his Nissan truck in Mr. Dinsmore's pole barn on the day of Holly Bobo's abduction. 2, Mr. Dinsmore testified that Shane Austin, Jason Autry, Zach Adams, and Dylan Adams showed up at his work on the same afternoon to purchase drugs, with Mr. Adams and Mr. Austin purportedly getting into an altercation about, quote, who was going to hit it first. In parentheses, it says, note that this future tense reference means that Holly Bobo was presumably still alive, which would have been inconsistent with the state's theory. That's a very good point. Or it was about the drugs they were purchasing, which to me makes more sense. I have a quick quote, I have this uploaded, of the mess Jason Autry was trying to tell this story on the stand in 2017.
One lick was exchanged. Zach hit Shane. Dinsmore pulls up. Dinsmore comes outside.
Like, he doesn't know who was pulling up where. At some point, a few minutes later in this testimony, he's going to forget that his storyline is, I'm in the truck with all the other three, and we've all been on this drive together to go to Victor Dinsmore. He's going to say, when I pulled up, the air was thick with animosity. As if, like, he pulled up alone, and the other three guys were already there in the midst of a fight. It's like his pictorial recollection isn't there for him to tell the story he's trying to tell with the visual details. So he's tripping himself up. I also see Defense Diaries must be here. Hey guys, love you guys. Hope you guys are doing well. Thank you for stopping by. Defense Diaries, I know you've been looking at this case as well. Still waiting. Do you guys know if you were going to have Doug or anyone from the Trial and Error podcast on your show? Because I'm sure the entire chat would love to know. So let us know when you plan to do that, guys. And Defense Diaries, again, they cover a ton of stuff, so you should check them out in general. But they've also done some coverage and shared their thoughts on the hot mess post-conviction relief proceedings that are going on. So make sure you check out that, because I know you guys watch things like 3 or 4 times. So make sure you watch it with them. Good to see you guys. Yeah, not the accent. I'm getting good at his accent. I think I'm getting good at his accent because his put-on accent isn't very good. So it's not really that impressive for me to imitate somebody else's bad acting. Just also bad acting. So Mary's like, I like it. I like the accent. All right, so they've got all this going on. Next, and this is the thing, guys. Every time it's like, it's the grocery shelf is too full. I'm forgetting all about the issues with the ballistics, the firearms. So here we are. Now that we're on page 9 and we've heard about 30 different issues. Now let's not forget the issues with the firearms, the changing story of the murder weapon, and the ignored .380 auto casing that is right next to Holly's skull. But the state's murder weapon of choice at the trial is, it was a revolver, which doesn't expel casings. So Mr. Dinsmore testified that Shane Austin later sold him the supposed murder weapon, a .32 caliber revolver eventually tossed into a creek by Mr. Dinsmore's wife, and then recovered by Miss Nichols and TBI agents in 2017, mere months after the trial. You know, I do love that he's specifying that Miss Nichols was there for this recovery. As with Mr. Autry, Mr. Dinsmore's reflections on April 13th, 2011 changed fundamentally over time. Also, like Mr. Autry, Mr. Dinsmore was interviewed multiple times, implicated without any evidence connecting him to the crime. He was told, you're facing 8 counts. So when Dennis Benjamin was going and speaking with Dinsmore in 2014, he was like, you're in trouble, buddy. You're facing 8 different counts. They're filing notice for death penalty, putting the pressure on. And in those April timeframes, that's when Dennis Benjamin, who's working as a private investigator for Karen Bobo, retired Memphis officer, swears he has only a 1 line of communication to TBI, that TBI is not giving him information, even though TBI agent Valerie Trout, who's no longer a TBI agent, was going with him on at least one of these trips, as memorialized by one of her investigative reports. Benjamin swears it was only one way. TBI never communicated with him the other direction. Anyway, so Dennis Benjamin's putting pressure on in 2014, in the spring of 2014, and who's the weak link? And Dinsmore says, it's Dylan. You got to go talk to Dylan. Dylan is the weak link. Dylan has the intellectual disabilities. He's the one to crack. So Dylan is already held on these federal gun charges with Jason Kilzer. Suddenly, he gets this plea worked out by U.S. Attorney Beth Boswell, who's also working as a state prosecutor on the Holly Bobo investigation. So she's double dipping. And she cuts a deal, and his probation condition is to go live with Dennis Benjamin, who just found out Dylan's the weak link. And I'm not making any of this up. Like, this is really what's happening. So if this is anybody's first day diving into this trial, and this motion that we're reading seems crazy in a bubble, it gets so much worse. It gets so much worse. And I gotta do the innocent man walking. I'm gonna have to pull that clip and like put it on the ready. I'll make it the intro for the streams. So we've got, well, let me take this down before people think I'm mocking Zach, because I think Zach is factually innocent, not just wrongfully incarcerated, wrongfully convicted. So yeah, Mr. Dinsmore, Doug's laying it out. Dinsmore's story changed, and it only changed after he's getting these individuals coming out to his house telling him you're facing the death penalty. You're not supposed to have guns at all. So even if we can't get you for what we're saying you're facing for crimes against Holly Bobo, we also know you have these guns and this drug activity you're not supposed to be engaged in. So we need your help. And there's also reward money, and I'd really like to see you get some of that reward money. That's what Dennis Benjamin's telling Dinsmore in 2014. So he's threatened with incarceration and even the death penalty if he did not, quote, cooperate. And you guys can probably guess why Doug put cooperate in quotes with TBI. Again, like Mr. Autry, Mr. Dinsmore eventually provided testimony that was in stark contradiction to his multiple previous statements, but in line with the state's narrative of the case. And finally, like Mr. Autry, Mr. Dinsmore was spared prosecution for a crime he had nothing to do with in the first place, in exchange for testimony implicating Zach Adams. Enter Dennis Benjamin. All right, Doug's going to lay out the whole I didn't even need to do it. Doug's going to say it better than I did. Enter Dennis Benjamin, Upon information and belief, Mr. Benjamin and his wife offered services to the Bobo family as some kind of private detectives of sorts, with an affiliation with TBI. Mr. Benjamin created an ersatz friendship with John Dylan Adams while Dylan was in prison in Obion County in 2013 on charges brought by part-time assistant. Part-time assistant. But it's true. Assistant U.S. Attorney Beth Boswell, who incidentally was the full-time assistant district attorney in Decatur County, whose office, led by Hansel McAdams, whose political capital was diminished. Oh, we need to do that stream tonight, guys. I'm going to make myself do it. Led by Hansel McAdams, whose political capital was diminishing greatly the longer an arrest in this case did not take place. So remember, abduction, 2011, April 2011. April 11th, 2013. No, 2011, April 13th, 2011. That's correct. April 13th, 2011. The audit for the 24th Judicial District, his district, Hansel McAdams' district. He's like their drug division, the civil forfeiture. Hansel McAdams is driving around a seized BMW, rolling up to community events in a BMW seized that's still in the civil forfeiture fund, that they haven't actually closed cases on. There's all these issues where people are poking around, taking the evidence for themselves, people taking the drugs and selling them. So the drug task force taking evidence and selling it for their own income. I think we got to do that stream tonight. I think we've got to read that tonight because, yeah, I think the climate is so important here. His capital has been diminishing because his people are running around arresting people and then messing up the cases because they're messing with the evidence for their own personal use. And he's just joyriding around in seized vehicles. So I think we got to look at that tonight. So bookmark that. The longer an arrest in this case did not take place. The TBI had moved on from the man, Terry Britt, who admitted to the federal marshal that he did it, a point of apparent minor consequence to the state, perhaps because Mr. Britt should have already been incarcerated for the 2008 rape of Tequila Jones. So, if we say Terry Britt did it, then you'd have to answer to the public and to the Bobo family why you failed to keep our daughter safe, a member of our community safe, because you failed to prosecute somebody else, the same person, the same culprit, for another rape. Because nobody transported her the day she was needed to testify at trial. But Mr. Britt was not incarcerated because at his preliminary hearing, Miss Jones failed to appear, and the case was dismissed for lack of prosecution. Miss Jones was in jail on a misdemeanor drug possession charge, and the state failed to bring her to court that day. Dana McClendon just did a video breaking down this Terry Britt, like why this Tequila Jones, like even at a top level understanding, it's ridiculous. But he breaks it down in more detail. I have it pinned as my top post on my X profile, but let me get the link real quick and drop it to you guys. Obviously, it's on the Trial and Error Podcast YouTube channel. It's 7 minutes. And I'd honestly recommend, if you have not seen it, watch it, come back over and catch up on 1.5 speed with us. So I'm just going to put Dana explains Brit problems. All right, so that's in the chat there. So great 7-minute rundown from Dana McClendon. All right, so they're ignoring Terry Britt. So back over here. Mr. Britt wasn't incarcerated because at his preliminary hearings, Miss Jones failed to appear because they failed to transport her, and the case was dismissed for lack of prosecution. Miss Jones was in jail on a misdemeanor drug possession charge, and the state failed to bring her to court that day. Of profound oddity, headline, what is going on? Dylan Adams, a young man with documented intellectual deficits and known to be susceptible to suggestion and manipulation due to these deficits, then went to live with Dennis Benjamin, the retired Memphis cop working as an unlicensed private investigator for the Bobo family, actively pursuing the Adams brothers as culprits for this crime. Several weeks into the investigation, or a living arrangement, Dennis Benjamin, I mean, might as well, right? I think the living arrangement, I can call it an investigation. Dennis Benjamin coerced a, quote, confession out of John Dylan Adams that served as the basis for the charge, but not the conviction in this case. And that's important because they're going to use it to get the indictment, and they have to change because his story is wholly incredulous. Of significance, Dylan's story was demonstrably false based on the testimony of Agent Frizzell, the attendant's cell phone records, and a complete lack of physical evidence that would have been apparent had his story been true. Dennis Benjamin's activities did not stop with Dylan Adams. In 2015, he travels to Indiana to visit Victor Dinsmore and told him that Victor was going to receive the death penalty if he did not tell Dennis where the body was. So now we're going back to Dinsmore and looking for more because Dylan Adams didn't pan out. But we've already indicted everybody. We've already indicted Zach Adams, Dylan Adams, Jason, and Shane Austin. And I think the Piercy brothers were in the mix already. During this conversation, Dennis Benjamin identifies himself as holding an influential position with both the Bobo family and the TBI, commenting that he was part of a recent meeting to determine Dinsmore's fate and I always forget what this stands for, but special agent in charge or something like that, Jack Van Hoosier. That's relevant because Jack Van Hoosier is supervising whoever's below him, like Terry Dykes at one point in time. So he says he can get Van Hoosier on the phone, asserting he has authority to offer Victor Dinsmore a deal to avoid getting charged for Holly's murder if he provides testimony to implicate Zach Adams in the crime. Mr. Benjamin's exact words will be submitted to the court, and suffice it to say, they will make Dinsmore's, quote, testimony understandable. He was also testifying to save his life after being treated terribly by the state and their quasi-agents. Thus, at some point, Victor Dinsmore chose saving his own life over the truth, and with the track record of this case, perhaps the court will be sympathetic to Mr. Dinsmore's approach when innocent men were being threatened with crimes they did not commit. So, Dinsmore gave a series of statements to both the TBI and FBI. Eventually, some of these statements gave details that the state happily accepted into the story they were creating about April 13th, 2011. The problem was, though, they became at odds with the version of truth the state decided to settle on when Mr. Autry had finished poring over the discovery sufficiently to tell the tale he did. Several examples. Mr. Dinsmore at some points denied the defendants were at Dottie Cooley's home with him on April 13th, 2011. So, this is from a statement on July 21st, 2011. Dinsmore was saying no. By 2014, Mr. Dinsmore provided, and parentheses says apparently, all we have is what TBI reduced to their own IRs, the investigative reports, and the accuracies of this will be revealed for what they are. But they're saying, so by 2014, Mr. Dinsmore provided a statement, apparently, because they don't have the statement, a statement that stated now definitively that Zach, Shane, and Jason were there on April 13th, 2011. At this point, Dinsmore apparently stated that, quote, Zach hid his grandfather's white Nissan post-abduction. Victor recalled Zach telling him the truck was hid because of an arrest Zach had been involved with, where park police caught him with methamphetamine, and Zach tried to run them over in his truck. Victor speculated the truck was hid because it was used in victim Bobo's abduction/murder. A polygraph was submitted by Mr. Dinsmore on 2 questions, both of which were whether Mr. Dinsmore did he see the victim on April 13th, 2011. He did not. In August of 2015, Dinsmore gave a new statement, IR 3000, hilarious number, where he now trots out the belief that Autry, Adams, and Austin were arguing about who was going to have sex with the victim, and that he assumed they had the victim stashed away in the house or cabin. This is an amalgamation of the habitual liar Dinsmore's original lie that he had heard Zach told Carl Statler while at Johnny's bar on one night that he had let Shane hit it, in reference to allowing Shane to rape victim Bobo after she was abducted. And now that IR, where we get this quote, this statement comes from 2014, March 2014. Around one of the times where Dennis Benjamin is making his first trips to visit Victor Dinsmore. In February of 2017, Mr. Dinsmore and his wife flew down to Tennessee for purposes of showing the agent the location where Sandy had placed, quote, the gun, which was characterized by him as several things. The question calls into this court the veracity of both the TBI agent who created the IR, whose name need not be presented here, in an IR whose activity was generated on 2/17/2017, but not reported until 6/12/2017, after the alleged gun in question was found. Mr. Dinsmore said that the gun was thrown away, was probably a revolver, possibly a .38 or .357 caliber, and he had given it to his wife to carry for her safety. Now we're all the way in IR to 3,139. However, in a follow-up meeting on May 19th, 2017, Mr. Dinsmore said, Shane traded me a black .38 revolver. That was one you could switch with a cylinder to make a .357. Dinsmore went further to state that this gun was thrown out by his wife. However, Mr. Dinsmore testified that there was a junky piece of shit .32 revolver. This was the same thing that when it ended, the TBI officer said, everything you said is the truth, and it ain't nothing I done to put words in your mouth. And then Dinsmore said, all you've done is jog our memories. So they don't want to say Brett or Brent Booth's name here. Of interesting note. During the trial, the witness testified fundamentally differently on whether the TBI agent did jog his memory. All right, so here's a transcript. So the question is, and then once again, you go through this, and then you begin to change your memory, don't you? So that's obviously Thompson doing this questioning. General Nichols, so Jennifer Nichols, says, Judge, I'm sorry. She's testifying and telling him that he's changing his memory. You've told her 3 times that there's a question to ask it. Ms. Thompson, that's a question. General Nichols, that's a comment. Ms. Thompson, you changed your memory, didn't you? The court, okay, ask your question. So Thompson says, you began to change your memory, didn't you? Dinsmore, after my wife and I talked, some things came back around, and she mentioned some things that reminded me of things that happened. Question, but by the time you finished talking to, and I'm assuming this is Brent Booth, redacted here, that day, you had recovered that memory, hadn't you? That was before that. We just told him that. Okay, so what you're saying now is you had already recovered the memory that Zach had put his truck in your shop? Shop? Come on, Jennifer Thompson. But you started out slow with Brent Booth and just were telling him, no, he hadn't put the truck there? Question mark. I wasn't sure at first, like I said, until my wife and I talked. And that's when we figured out, yes, it was there, and my daughter confirmed it, so... Jennifer Thompson says, so I'm not understanding. When did you and your wife talk? Before or after Brent Booth came to talk to you May 18th, 2017? And that's not redacted, but okay. We talked before, after. We talked last night. We talked on the way to court this morning. But when did you and your wife talk about the fact that the white Nissan truck was parked in your shop? Before blank came up. Before blank? Yeah. Was it that time before blank came up that you had realized that yes, in fact, the white Nissan was parked there? Yes, but I just didn't remember them saying that they had to move some tires out. I had a big shop. I didn't think there was any reason. But then my wife clued me in and said, yes, they moved the tires. And then I remembered. I had some tires off of a van that I scrapped the van. I kept the wheels and tires laying in the way. Now, so Jennifer Thompson, defense counsel, does not play the recordings that are obviously showing that this is false. Because you go from, it's like the 18th of May and then the 19th of May, back-to-back days, where Brent Booth is there and speaking with the Dinsmores. And on the 18th, they're saying, no, this stuff wasn't happening. And then within that same 18th call, before anybody goes their separate ways, Brent Booth is teaching them what Jason Autry is going to testify to at trial. And what would help him if you also say the same thing. So it's not like this information, you can hear it in the recording, how they come to remember and change their mind on what happened. Because they say so by the end of the call. The 18th. Also on the next day, because they changed their mind within the same call on the 18th, Brent Booth has to go back the next day because Jennifer Nichols was concerned that he was suborning perjury, that he was putting words in their mouths. So that's why on the 19th, they reiterate, no, you didn't put words in her mouth. You just helped me jog my memory. I talked to my wife and then talked to my daughter. But they had already changed their story within the solid recording from the one day before anybody went their separate ways and had a time to talk without Brent Booth there. So this is obviously untrue. And Jennifer Thompson doesn't play the recordings. The jury doesn't hear those recordings. I don't think this is an effective way to call him out on what he's doing here. And then even worse, the prosecution's fine with it even though they know better. So the state did not object to this blatant perjury. In fact, they were objecting to the jury hearing any type of inkling that it might not be true. Mr. Adams' attorney did not request a mistrial for prosecutorial misconduct, and such was ineffective assistance of counsel under the U.S. and state constitution. To be clear, the tomfoolery really began in May of 2017 prior to the trial. The day before, the same TBI officer who was involved in prior statements came to serve the subpoena on Mr. Dinsmore for trial. This is where the state did several things. A. Fabricate evidence. B. Begin suborning perjury. And C. Create a timeline that was and would remain completely impossible under the facts known by the state at the time. On May 18th, 2017, is when the TBI officer came to Mr. Dinsmore. This officer was referred to Mr. Dinsmore as a buddy. A transcript and recording of this conversation will be submitted as evidence. Several highlights. TBI officer says, "There's been some developments. Let me talk to you. Jason has rolled. And let me tell you what'll be testified to. This might help you remember." He says in the part that involves you when he came over to you. And he said Zach got out of it, and first thing he done was punch Austin right in the face. So that's Shane Austin. So that's part of the transcript. At this point, Mr. Dinsmore has not been read on the story the state will present to the trial because he says totally inconsistent. He says totally inconsistent with what will be produced at trial. I think it's supposed to be because what he says is totally inconsistent with what he'll produce at trial. Quote, "Yeah, they started scrapping. Now I remember what they was saying. They were fighting over who was going to hit that little bitch first when they got back. That's what they were saying. So that was Holly." TBI goes on. He says that also Zach had taken his truck and put it in your garage, and then he told you, or he had seen you when he brought it over there. Sandy Dinsmore says, "Me?" And you can listen to this on the Trial and Error podcast. They have a good chunk of these recordings uploaded on episodes 9 and 10. TBI continues unfazed. He, Adams, saw you when he put the truck in the garage. And I know the truck was there. No, it wasn't there because we've pulled recordings and pulled tapes from 911. And Dick says Dick is Zach Adams' grandfather. Dick says that the truck, he didn't have his truck that afternoon. That he had taken it to your house, your garage. Victor Dinsmore, it wasn't at our house, bud. No way. TBI starts scratching around. Could he have done that and you not known? It ain't gonna matter. I need to nail this down because this is what's going to be testified to. Dinsmore, no, I know it's not gonna matter. More in denial by Dinsmore takes place. They talk about the gun and that the Dinsmores threw away. Then back to this Nissan truck in the garage. Sandy Dinsmore said she remembered that in an unrelated issue with the Natchez Trace, Zach left the white truck outside and not inside. TBI was not happy and responded, "Well, supposedly that's what he says. That's what's going to be testified to. They had to move 4 rims to get it in there, and that he," interrupted by the question, "4 rims?" I think that's what Sandy's saying in the background. "Saw you when he was putting it in there, and you knew it was. You saw him putting it in there, but you didn't know nothing. It ain't nothing wrong with it. I'm trying to nail it down." Dinsmore starts to crack and says, "I don't know." TBI seizes the opening. "You wouldn't have thought nothing about him putting it in there." Dinsmore right on cue. "By God, he might have known. It's redacted. Damn it." I think he's saying Brent's name. And then Dinsmore adds great credibility to his memory. "You know, I was doing a lot of dope right then, okay?" And I mean, the meth and stuff, but he might have. TBI circles back. according to what Jason is going to testify to, is he told you that when he pulled up over there at Dottie's, he said, I put my truck in your garage. I saw Sandy, and she knows it's there. I had to move 4 rims to get it in there. This testimony requires that by the time Autry and Adams see Dinsmore, the truck has been hidden and Dinsmore's wife told as much. The state cannot now rearrange the events. Dinsmore responds to TBI by saying, no, that didn't happen. His wife adds, I don't remember nothing like that. Mr. Dinsmore responds, no, she would remember that. That didn't happen. TBI unfazed continues. Could it have happened? Dinsmore never missing the cue. It could have happened. Relieved, TBI says, okay. Dinsmore, it could have happened, man. I can't say no, damn it. TBI in a true statement says, I know. Dinsmore, I was smoking weed, I was drinking liquor, I was doing meth, and I just didn't want to be here no more, so I can hardly remember, so. TBI, it helps me. It helps this case, if you can remember. The more pressure I put on him, the more you all can remember. The more it helps push this damn case to where it may get a plea. That's what I'm saying. May get a damn plea. And then Dinsmore asks, when asked if there's any chance Adams and Autry gets out, TBI says, well, you never know what a damn jury's going to do, but I've got to know. It's got the more details that I can nail down, the better I am. Dinsmore's next response, put that truck in my garage. A little bit later, Dinsmore adds, yeah, let's say it happened. The petitioner would query if this court would ever come across more blatant coaching of a witness and more fabricating evidence than this May 18th, 2017 encounter. It was so bad, the next day the same TBI officer was apparently concerned enough, or his boss or DA was so concerned, that the TBI officer stated the recorded part of the conversation, as stated above, to say, I didn't want to put words in your mouth, which is exactly what happened. The state was unconcerned and put the following testimony in evidence. Question. Is that the shop that Zachary Adams hid his grandfather's white Nissan? Answer. Yes. He hid the Nissan in the double door right there and was pointing. Question. Okay, thank you. And I take it that you indicated that you do not recall there being a discussion about that Nissan on the day of the 13th, but that you know that the truck was hidden. Yes. In that shop. Yeah. After Holly went missing? Yes. You freely gave that information to law enforcement when they asked you? Yes. The state intentionally asked you freely gave that information that Zach Adams hid the Nissan truck in the garage on April 13th, 2011 to law enforcement when they asked you? At no point did the ineffective counsel, Jennifer Thompson, ask for a mistrial based on this question and answer. But for the ineffective cross-examination and failure to ask for a mistrial, this issue would perhaps never be known to be fundamentally and demonstrably proven to be the lie that it was. Because we now know that the morning of April 13th, 2011, at the Northeast East Sector, Mr. Adams had to travel from 10:32 a.m. and do the following. He had to travel back to drop Jason Autry off the approximate 25 to 30 minutes. This alone creates an impossible timeline as the route needed from the river to dropping Jason Autry off, to picking up Shane Austin, and then Dylan Adams and get to Parsons. From the theoretical timeline, it would appear that this is the window that Mr. Adams and crew then somehow drove to where the remains were eventually located. But again, the victim's cell phone had already been there from 8:30 a.m. to 9 a.m. And then the cell phone was found later at Gooch Creek in a route one would expectedly expect if its final destination along a route that began at the Bobo Swan Johnson home, continued to where the remains and an untested .380 auto casing were found next to it, and ended at the home of Terry and Janet Britt. This would take a sufficient amount of time that further makes the timeline absolutely impossible under any timeline imaginable. But it gets more and more impossible the more one has to consider that the proof submitted and the state's theory of the case is that the victim was removed from the Nissan truck well before Adams sees Victor Dinsmore in the early afternoon. Thus, the defendant would have had to do all of this before the trip to Parsons and before the encounter with Victor Dinsmore. Further, he can bend time. Further complicating the state's theory absolutely falls apart when you review the afternoon of the defendant's cell phone activity. Victor Dinsmore's testimony, and Jason Autry's testimony. There's virtually no scenario imaginable whereby the defendants somehow went back to where the victim's remains were found that afternoon, in time to then put the truck in Victor Dinsmore's pole barn / garage, and also run to Victor Dinsmore's and have a fight with Shane Austin, who is presumably still in his home drinking beer, per the state's own witness, the satellite installer. I forgot about the satellite installation. Oh my gosh, I forgot about the satellite. Remember, they planned this whole murder to make sure Shane wouldn't miss his very important installation window, because it's a pain in the butt to reschedule those. It is important for the remains to have been removed from the truck. Then the defendants clean the truck to remove every trace of DNA particles, though it could be argued possibly the truck was bloody and Sandy, while not only never remembering the truck going in the garage, she never remembered a truck with blood going in the garage. Then clean out the Dinsmore garage to move the truck in, talk to Sandy about all of this, all while Shane Austin is at home, per the testimony of satellite installer, which is the state's witness, and corroborating cell phone records of Shane Austin. All right, so legal grounds for relief, which the state has been screaming there are no legal grounds for relief. Just crazy. New sign, and don't forget, Shane Austin also had burn barrels going on at this point in time. So there was all this talk about the burn barrels at the 2017 trial, but nobody burns Holly's belongings in these burn barrels. They just throw them along the side of the road like Hansel and Gretel crumbs. Like, why are you telling us about burn barrels? Like, I think the burn barrel was their reason. They were trying to say that's why we didn't find Holly's remains for years, because we didn't listen to U.S. Marshal John Walker. But they didn't burn any of her stuff. They just keep mentioning burn barrels. Oh my goodness. So, new scientific evidence of actual innocence. So the ATM video timestamped at 11:12 a.m. on April 13th, 2011. Now remember, this is all taking place between 8:30 in the morning and 11:12 a.m. The state has to make everything that they claim happened from the moment of Holly Bobo's abduction reconcile. And I even say before the moment of the abduction. Reconcile with how these guys are all in Parsons, Tennessee at 11:12 a.m. So this constitutes new scientific evidence demonstrating petitioner's actual innocence. The state previously represented that this transaction was not captured on video, and that's why those IRs are so important. Remember when I scrolled back up and I said, we're going from like somewhere in the thousands to this 2000s IR report, which presumably comes after, where Joe Walker, TBI agent Joe Walker, is representing that there were no other videos, meaning that this CB&S video, it didn't exist, even though it was memorialized with a longer file name in an earlier investigative report, and that file name would change to make it renamed as BP instead of saying Community South Bank Parsons April 13th, 2011 as the file name. So very important, the state previously represented that this transaction was not captured on video, and later misrepresented or mislabeled critical discovery material, rendering the exculpatory footage effectively inaccessible to defense counsel. Petitioner's trial counsel was unaware of this evidence reflected on the video due to these acts of concealment, and thus the claim has not been waived. This evidence, viewed alongside corroborating cell phone tower data and testimony that places petitioner far from the alleged crime scene, meets the standard under Tennessee law for actual innocence. So they're citing Dellinger v. State, and saying that petitioner is entitled to relief where clear and convincing new evidence proves innocence. The newly disclosed ATM footage conclusively supports that claim, proves the state used perjured testimony, and proves that the state violated constitutional rights to a fair trial, and proves that Mr. Adams' trial counsel was ineffective. 2. Brady violation and prosecutorial misconduct. The prosecution's failure to timely disclose materially exculpatory evidence, the ATM video, violates Brady v. Maryland and its Tennessee counterparts. The state not only failed to provide this evidence upon request, effectively buried the exculpatory evidence in a digital mountain of irrelevant evidence, and also misrepresented its nature, and failed to fulfill constitutional obligations to provide the exculpatory evidence when defense counsel indicated they were unable to access it. Next, the state knowingly presented materially false testimony from Dinsmore and Autry regarding petitioner's whereabouts and actions on the morning of April 13th, 2011. This conduct violated the Due Process Clause of the 14th Amendment and Article 1, Section 7, 8, and 9 of the Tennessee Constitution. This includes specifically the irreconcilable difference between Jason Autry's, quote, route he and Zach Adams must have taken and the timing it required to do so and be in Parsons at the CB&S Bank at 11:12 a.m. Oh, so Britt, there's some, on Facebook, someone posted that it looks like his house has been vacated, that he and Janet no longer are at their property, and he's free. He was released, I think, March of this year. I think it was earlier March of this year. It might have been March of last year, but I think it was March of this year he was released from prison. So he's a free man. He's a free man walking. So, before an accused is entitled to relief under this theory, he must establish several prerequisites. That the defendant requested the information, which they did, unless the information was obviously exculpatory. B, the prosecution must have suppressed the evidence. C, and yeah, I think the ATM video would also fall into the second part here. So they don't even need to request the information. It should have just been disclosed appropriately and not concealed. B, the prosecution must have suppressed the evidence. C, the evidence suppressed must have been favorable to the accused. Do you think the evidence suppressed helps the state? And D, the evidence must have been material. So, not a lawyer here, but backseat juror, I think all of these criteria are met. Because if I was a juror at the first trial that deliberated and came to the same conclusion as the jurors in the first trial, and then you told me this, I would be flabbergasted. I would be pissed. I'd be doing news interviews. I'd find Nick Barris. Nick Barris would find me. And he'd be like, this is a juror from the former trial. Tell us what you think about this new ATM. And I'd be like, it's blasphemy. Oh, man. They say because trial counsel was unable to know truly the falsity of this evidence because it did not have the ability to watch the reference video, it was not a waived issue. Alternatively, to the extent it was, then this argument falls to the ineffective assistance of counsel ground. Now they're going to go into ineffective assistance of counsel. So, to the extent that this court finds the ATM and cell data evidence and the perjured testimony of state witnesses could have been discovered, revealed, and or admitted at trial, petitioner asserts ineffective assistance of counsel. Trial counsel failed to file an effective motion to compel access to the video discovery or to establish a concrete evidentiary timeline. Counsel also failed to move for a mistrial following multiple instances of prosecutorial misconduct, including the use of perjured testimony. Under Strickland v. Washington and Baxter v. Rose, petitioner was deprived of effective counsel, rendering the trial fundamentally unfair. These failings, both individually and cumulatively, entitle petitioner to a new trial. Any effective counsel claims would have pierced through this all at trial and acquitted Mr. Adams. And you could not tell me otherwise. I would be very scared if 12 jurors could see the way Doug just broke down this ATM issue alone. That issue alone. I'd be surprised if there wasn't at least a holdout that said reasonable doubt, let alone all 12 finding reasonable doubt. Maybe all 12 thinking actual innocence, full alibi. But then you also add in the issue of the Dinsmore and Autry getting their story straight. Like, we don't even need to get into third-party culprit territory and trying to prove that Terry Britt did it. Just the way that they crafted the testimonies of Victor Dinsmore to match Jason Autry. And they helped Jason Autry by making sure he had the phone records because their first trial and error test run using Dylan Adams' story contradicted the hard, tangible phone evidence. So they said, oh, well, maybe we'll get these phone records to Jason Autry and he'll do a better job coming up with the story. Like, every step in this timeline is like a critical piece that tells the story of the prosecutorial misconduct that took place here. So, and the jury just didn't get to see it presented. So any effective, in this case, is going to have to be moved for a retrial, right? I mean, I would hope so. I would hope so. I don't know. I would kind of like to see this trial. Can you imagine this trial, but with Doug Bates or maybe even like Crystal? Because I don't know what part. I think Crystal's done a good job and we've got to see her. I'm sure she's helping write these motions. But I would love to see a new trial with this judge, with this defense counsel. And I don't think Judge Nichols would come back. She's a judge now. So this prosecutor that we're hearing about, Jennifer Nichols, she is now a judge. She is now a judge, guys. But it'd probably be Amy Wyrick and Matt Boiano staying on. Amy Wyrick's coming over to handle these post-conviction matters as a special prosecutor. I would imagine she'd probably want to stay on for a retrial if there's a retrial. And I would just love to see this go down with the new players and what we know now being available. Yeah, don't remind us she's a judge. But it would make sense also if they're seeking to move further and further away. Although I think the media coverage, I do think there's some penetration where people are hearing like, oh, it might not be that they found bones in Zach Adams' backyard and he's a druggie and he was saying that he did these horrible things. That stuff's not true. We have bad information and we never corrected it. Like, I don't know how the sentiment might shift nearby. But of course, that's a risk when, like, think of the upheaval in the community if Zach Adams is given a retrial. Because all of those community members got on the stand, the ones that were called to testify, and said that they were here because they wanted to put an end to this. They wanted closure for the Bobo family. There was such an emotional investment from all of these community members, beyond just those that were called to testify at trial. No way, DV with the T. So Crystal E2, so co-counsel here with Doug Bates, was a cryptolinguist with the NSA. Well, that would be fun. That would be fun. I love to hear and learn new words. So that's actually why I like part of the reason of reading motions. There's, this type of stuff, there's vocabulary being utilized that you don't see in other things that you could read. So we've got any effective defense counsel would have pierced through this all at trial and acquitted Mr. Adams. And now Bradbury started as a public defender. So the current judge that's presiding over these post-conviction relief hearings, he's been on the defense attorney side. So I kind of wonder if this is just like something that'll be understood innately, like without even having to think about it. Any effective defense counsel would have pierced through this all at trial and acquitted Mr. Adams. The petitioner thus has a conviction that rests upon the denial of effective trial counsel that resulted in an unreliable or fundamentally unfair result, under both the U.S. Constitution 6th Amendment and the Tennessee Constitution Article 1, Section 9. This statement applies to each and every allegation individually and collectively above to the extent that the standalone claim fails. So we're doing the cumulative error. They have not been waived and are ripe for this court's ruling. So prayers for relief. Petitioner respectfully prays that this court vacate and set aside the jury's verdict and judgment of conviction, order a new trial, or in the alternative, dismiss all charges with prejudice, and then grant such further relief as the court deems just and proper. Now, what would be interesting, I would love to watch, and we will get together to watch this, if we get like relief number 1, and a new trial's on a set for whatever, the state wants to appeal that decision, which is going to tie up the timeline. It's going to take forever. And then Zach moves for bond in the meantime. And then there's a bond hearing. There's a fight for bond. I would like to see that argument. I think that's it. So we get our signatures here, or they don't sign this. All right, there's Doug. There's Crystal. And then, what did they attach here? Ooh, I love this. Guys, they have a timeline. Oh my God, this is great. I think, guys, if you want to send a document to, what is this? The petitioner's proposed addition to Second Amendment. This is still the live link from the Tennessee court's media page, but I really think if you sent this to someone who has not looked at this case yet, The same way, like when we do a what in the video and we look at some case appeal and it's like, what the heck happened in this case? And we're only reading like an appeal brief. I think this document that we just read would be a great blind read for anyone. So I'm going to mark this blind read. It is a link to the document that we're reading. I think this is the one to share, especially because it has this timeline down here. So their Exhibit A is just a comprehensive timeline, April 13th, 2011, and related developments. This timeline integrates verified data, disputed witness claims, procedural milestones, and post-trial discoveries from the original and amended post-conviction filings. It is organized by category and presented in chronological order to illustrate the breakdown between the state's narrative and the documented facts surrounding the Holly Bobo investigation. So here's this 8:30 start point. So first, verified evidence based on digital records and video footage. So between 8:30 and 9 a.m., Holly Bobo's phone pings near the site where her remains are later found. This undermines the theory that the victim was in Zach Adams' possession during the time frame alleged by the state. And she certainly wasn't in somebody's basement, which was the story that the state would have had to go with if they relied on Dylan Adams. 10:32 a.m. Zach Adams' phone pings at Tower 39077 in the Northeast sector, placing him far from the route described by Jason Autry. 10:35, and give me a second, I'll pull up, I don't have a good picture of it, it's like a screenshot I grabbed from Trial and Error podcast, but it is a map that is now an abduction, an exhibit. All right, let me make this full screen and share this. So let's finish reading this timeline real quick, and then I'll pull up the map and we can try to follow along. So 8:30 to 9, her phone is going to stop for a period of time. Like, it's the last time that her phone's pinging. It's not moving anymore. And then years later, even though U.S. Marshal John Walker tried to say, go look in this area, right away, like a few months after this happened, still 2011, he's like, go look here. This is probably where you'll find her. They don't do it. They don't find her remains there until 2014, when this ginseng hunter happens upon her body. So they've got a 10:32 a.m. Zach Adams' phone pings at 39077 in the Northeast sector, placing him far from the route described by Jason Autry. 10:35, Adams' phone pings Tower 39079 in the Northwest sector, confirming westward movement towards I-40 and that they're not using back roads. 11:12 a.m., the ATM footage shows Zach Adams, Dylan Adams, and Shane Austin at the Community South Bank in Parsons in a Silverado. This single video undermines the state's entire trial timeline, which is probably why it was hidden and renamed. And then, oh, we had it at one point, but now we're going to say we don't have video from it. 12:35 p.m., Zach Adams' cell phone activity continues in Parsons, confirming he remained in the area until at least mid-afternoon. And then now, before we get into the disputed timeline, I just want to give you a visual. So down here, we're having these are all pings for Holly's cell phone only. So what we're looking is the pings for Holly's cell phone. And remember, this is more accurate because the first deputies to get to Holly Bobo's house, they called AT&T and they were getting different phone pings. And they asked for like 15-minute intervals, and they could have asked for more precision, but they didn't. That's what we've got. So early in the morning, she's still at her home all the way down here. Then we have some movement. We get a reading. We got a bing, bing, bing. This is around 8:16. She continues to move northward. So she's moving up towards CR 1096. And then she's in this area for 30 minutes. So with this cell phone read, this is the area that really should have been the focus. So her phone is here from 8:26 to 8:56. 30 minutes. They'll ultimately end up finding her remains where this dot is right here. Then we have some other movement here, and this is where it's believed that her SIM card and phone were separated, thrown apart. They end up recovering all the way down here. When we heard that mention of Gooch Creek and Terry Britt's home, the Britts live in this area. And this is where they end up finding the cell phone and a lunchbox and notebook near the Britts. And the state's theory is that this was Dylan Adams driving and throwing the stuff out the window at the behest of his brother's instructions. That's how the state tries to explain this stuff. So, fun times, fun times. Additionally, and this might take me a second, so give me a minute, you guys. DB had done like an incredible job putting together. Let me find this map. Like, the stuff you can do with Google Earth is incredible, but I've never seen somebody do this for a case. It looks like DB should be working as an expert witness, and that Doug, he should be calling DB up to the stand and say, hey, can you like explain this to us? Are you just like a Google Maps expert? It was a bit ago. Let me find. And I really should have pinned it. I think it's in the description of one of these streams that we did recently. But we have a busy chat over on Discord, so it's going to take me a bit to scroll and find it. Oh, okay, got it. That was faster than I thought. Because what's really important, so where we're zoomed in on this map, it's really, you can see how close. This is not a very large, when we add Parsons and we add where they go to whatever, I think they're just doing drugs under this bridge. The map's going to be much bigger. We're going to be zoomed out. So this is how close Holly's home, where she is, to this area where her cell phone and lunchbox are found, which is very close to the Britt's home. Oh, okay, it's a new one. Thank you. Yeah, that'd be great, because whatever I opened was all funky. So let's get the nice fresh link. And while we wait for that, let me keep reading this. We'll keep going down this timeline and we'll jump back to the Google Earth maps. So, disputed or recanted testimony from state's witnesses. So 9:35 to 10 a.m., Dylan Adams falsely claims Zach Adams and Jason Autry were with Holly Bobo at 256 Adams Lane. No physical evidence supports this. Cell and video records refute it. Jason Autry's trial testimony. Jason Autry's back road route from the Tennessee River to Yellow Springs Road is 32 minutes long and unsupported by any cell tower data. His timeline is physically impossible. Victor Dinsmore, the TBI interview, May 18th, 2017. And we've got to specify which interview it was because it changes. So, under the pressure of a TBI special agent, Dinsmore changes his testimony from a total denial to stating, let's say it happened, about the truck allegedly being in his garage. Shane Austin transaction records. Bank records confirm Austin's transaction at multiple locations, placing him in town and far away from the alleged abduction path. These records are consistent with the verbal statements of Shane Austin, Zach Adams, and Dylan Adams to law enforcement regarding their whereabouts and activities on April 13th, 2011. Now, this is really important. They don't explain why in what they're asking to add to their petition here. But the state's theory is that Shane Austin, his build, his stature, honestly, I think they tried to portray a creepy demeanor for Shane Austin during the trial. Shane Austin was their way to say he was the actual abductor because his physical description could match what Clint Bobo, Holly Brothers, described the assailant to look like. Zach Adams was doing meth, was way too thin, was not the right height to be the person who was actually doing the abducting. Clint Bobo said one guy, barrel-chested, walking with Holly towards the woods at the end of the property line. So Shane Austin, pretty critical that he physically could not have been there because of the group, where they all have this shared responsibility for the crimes committed. The state was like, well, it could have been Shane that was the one that actually did the abduction. Well, he physically wasn't there. So, procedural and investigative milestones. September 20th, 2013. TBI logs digital evidence labeled BP Community South Bank ATM, April 2011, as part of Investigative Report 1845, but later mislabels it. This is a great timeline. I love this. September 22nd, 2014, search warrant for Dylan Adams Silverado is obtained based on a false confession. No evidence of Holly Bobo is found in the vehicle. 2016, CB&S Bank responds to defense subpoena stating no ATM video was located, a statement later proven to be false by its existence in TBI's possession. And this is important again because it shows that the defense, they reasonably believed that they had no way to access this. So May 13th, 2024, this is during the post-conviction proceedings. This is the subpoena gate. State issues subpoena for ATM recording devices and asks bank not to disclose it, violating expected discovery courtesy. June 12th, 2024, state finally acknowledged possession of ATM video during post-conviction litigation. And then March 20th, 2025, state admits ATM footage had been labeled as BP video during trial discovery. So, yes, maps are critical. And like, again, I get that there were maps presented at the trial, but it was essentially like, here are bubbles of cell phone towers, and Zach's phone is where Holly's phone could have been around the same time. But Zach's home is also located there, and he hadn't moved for most of these hours. That would suggest that he's just in his home. Maybe sleeping. Maybe using his grandma's computer to talk crap on Facebook, like, which matches the Facebook records, you know. So, but in the jury's mind, they got to see a map that showed 2 overlapping bubbles. Oh no, they must be in the exact same place and time because it's not properly explained how this tracking works. So, oh my goodness. All right, so let's try this map link. Let's get this pulled up. Thank you again to DB. Open it from YouTube. Here's the Earth. It is round. Oh wait, do I have to click something to zoom in? Oh, it's just loading slow. Let's add the key locations filter. And maybe it would help if I close the other Google Earth link I have open. I was referencing, I forget what it's called, but it's the old little video that was like, but I'm tired, where it starts off as like, here's the Earth. All right, let's go to, because we are in Brazil, but I'm going to need an address. I'm not going to be able to zoom in and find it. Great, we haven't, oh, okay, wait, there's dots already. That's helpful. I was going to say we have this nice AI summary on the right side. Yeah, see, now this is looking pretty flat, you guys. All right, and actually I think this is kind of, so this blue line, I love that you added this. So this blue line here is like what we were looking at, that route. But you see these bubbles all the way over here. You see how I said we're going to zoom out, and it's going to be a much bigger area, which is important because it takes longer to drive from an area that's farther away to another area that's farther away. So this area all the way over here that we need to add in to make Jason Autry's story sort of work at trial, they've got to get over to this Birdsong Bridge all the way over here, which means you got to drive all this extra distance from where we otherwise, and again, the state's theory is, well, maybe Dylan took this spoke. Dylan drove down this spoke and was throwing the belongings, getting rid of the evidence. So Even if we assume, all right, the abduction happens down here, Holly Bobo's home is down here, we go all the way up here, her remains are going to be found over here ultimately, and that's, her phone stops 30 minutes over here. Somehow between 8:30, the abduction, and 11:12, Holly has to be taken all the way over here to this Birdsong Bridge after they go to Shane Austin's house, which I forget exactly where, but it's like over here somewhere. And then Jason Autry's like, oh, there's somebody in the back of the car. And Zach Adams is like, yeah, I need you to help me move a body, get rid of a body. And he's like, okay. And then they decide they're going to go to this federal property, over to this bridge where people go to smoke and do drugs, which is kind of weird because if that's where people regularly go as the spot, might be a good chance that somebody would be there. Somebody else would be there. The riprap location is crazy. And then we go all the way over here. We got to drive all the way over here. We got to pull up. We got to be on the lookout, make sure nobody's looking. We got to get her out of the car. Oh, her foot's moving and I hear a groan. And she's not dead. She's already heard my name. Jason Autry's panicking. Heard my name. You already were down to get rid of the body. What did you think was going to happen? So, according to Jason Autry, Zach goes to the back of the pickup truck, grabs this pistol that he'd seen Shane have at some point, and shoots Holly while she's positioned on the riprap in the back of the head, because he knows in evidence that she was shot through the back of the skull. Then he says it goes boom, 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 and that a boater spotted him. And some boater is going to show up at the hearing on Monday and say they heard this gunshot on this day. Even though they've never spoken to anyone before, there's no investigative report about it, there's no statement, they weren't at the first trial. They're apparently supposed to show up during these post-conviction proceedings to say they heard a gunshot that day in this area. Then they're like, oh no, we've been spotted, we can't leave the body here. So they have to put the body back in the truck, and then they have to go get rid of the body. And Jason Autry has to be on his way to lunch to meet with his girlfriend. He's got to be there by 10:30, 11. So he's got to go. So Zach Adams is now on his own, taking this body to apparently where her remains are found. He's got to make it all the way back over here. And then somehow he has to get all the way down here to Parsons. He's got to get all the way down here to where he's going to be driving backwards through an ATM. His brother's going to run into a store and buy something at the convenience store. Shane's going to do deposits. They're going to put more gas in. Don't forget they stopped to get a little bit of gas somewhere. I don't know where the Shell station is. But they stopped to get gas somewhere else before they drive all the way down here. They got to put like $5 in the car. So that takes time. Takes time, even if it's just a quick pump. Takes time to put gas in. And they've got to do all that before 11, 12 a.m. the same morning. How do you do all that between 8:30 and 11:12? And again, that's not adding into the details where, Dylan Adams says they were like raping her in the basement and then they went into a bedroom for an hour to 2 hours. Yeah, the explanation was the echo off the bridge. The echo off the bridge. And who was doing the cleaning? It just doesn't make sense. So, thank you for that map, DB. Super clutch. Very, very much appreciate. And I'd never actually seen this filing before. I think it's a great filing. Again, I think this would be a great blind read for anyone who's new to this case. And it's the first time I've really seen them spell out this timeline. We've tried to listen to, we figured all this out by listening to Doug during these hearings, saying out loud these different details. But I really like seeing them spell it out in this motion as an exhibit. And then there was another exhibit here. So, a summary of witness coaching, Victor Dinsmore and the Tennessee Bureau of Investigation. This exhibit summarizes documented evidence of improper witness influence, including the Tennessee Bureau of Investigation, TBI, and Victor Dinsmore. The events described occurred primarily on May 18th to 19th, 2017. These are the Brent Booth visits, where he has to go back on the 19th and say that, I didn't want to put words in your mouth, and were central to the prosecution's theory that Zachary Adams stored the Nissan truck used in the alleged abduction in Dinsmore's garage. The TBI's actions constituted coaching, psychological pressure, and manipulation of a key witness, actions which raise grave concerns under due process principles. Timeline and content of witness coaching. May 18th, 2017. So, the first day of these recorded calls. A TBI officer visits Dinsmore and informs him that Jason Autry has rolled and is now cooperating. The agent explicitly tells Dinsmore what Autry is going to testify to and says, "Let me tell you what'll be testified to. This might help you remember." Same day, key allegation, so also on the 18th. TBI informs Dinsmore that Autry will testify Adams stored a white truck in Dinsmore's garage after moving 4 rims. Dinsmore emphatically and repeatedly denies the event, saying that didn't happen. And what I think is interesting is when you listen to those recordings, Sandy Dinsmore and Victor Starr, Sandy remembers, hey, no, Zachary Adams didn't even have that truck at that point because he was asking to borrow one of ours, like Victor's brown truck. So Sandy actually had a recollection of Zachary Adams' April 4th arrest in Natchez Trace Park, where they impounded his vehicle. And his grandfather, they went and get it the following Friday. And then they supposedly go and store it at a relative's house. And it's like, when being questioned, Zach Adams was like, I wouldn't even have had a white truck, because they thought a white truck was spotted and a white truck might be involved in the abduction. And he tried to explain, well, I wouldn't have had the truck then. This happens. So what I think had to happen here is the state had to figure out a way that Zach Adams actually did have access to his truck, and he used it for the abduction, knowing nobody would think he had access to it. In other words, showing forethought, planning, and crafting an alibi in advance for himself. That's the only reason I can think that they need to make this timeline match. But what's interesting is, without being prompted, Sandy Dinsmore was like, no, he didn't. It couldn't have been Zach's white Nissan because he didn't have that truck at that time. He came to borrow our truck because he didn't have it during that time period. Maybe we have the wrong dates, and you can hear her trying to figure it out. But she has that accurate recall that it could not have been in their barn. So let's see. And Doug doesn't really get into that detail in this document, but I highly recommend listening to those recordings. So they've got the TBI agent presses further, suggesting it could have happened without Dinsmore knowing. Dinsmore continues to deny until the agent intensifies pressure. It helps this case if you can remember. The more pressure I put on him, the more you all can remember. So Dinsmore shifts. Eventually, Dinsmore says, by God, he might have, and later concedes, yeah, let's say it happened. Corroboration. Dinsmore admits he was using drugs at the time and had difficulty remembering anything clearly. He says, I was doing a lot of dope. I can hardly remember. May 19th, 2017, the following day, the TBI agent, now concerned, begins the recorded portion of the follow-up meeting by saying, I didn't want to put words in your mouth, implicitly acknowledging the prior day's conduct. And I think, for me, this alone is bad. Someone having to come back and be like, oops, I didn't want to put words in your mouth. I thought about it overnight. Maybe one of my companions with the state was concerned about the way I got you to say these details. So I got to come back and clean it up. Like, that alone, this in a bubble, I don't know why it's doing this giant line, but that alone was troubling to me, just that little part. That alone, let alone everything else. Defense diary says, did they see anybody? So there were initial witness reports that there may have been a white truck in the area. And what's interesting about that is sometimes it's a full cab, sometimes it's extended cab, sometimes it's like the tiny little truck with only like a 2-seater cabin. But there was rumor of a white truck being spotted. And funnily enough, Terry Britt had a white truck that he did some DIY painting and took a paint gun and painted it black after this was happening. So, just so we don't forget that Terry Britt's in the mix here. But yeah. So there was just rumors of a white truck. So they need to connect these guys, these drug addicts, with a white truck to corroborate that they were the ones that did this. So yeah, sometimes it's a Google image. So good times. I think that was a great motion. Again, that was May 2nd. I'm going to end up highlighting this one for easy sharing. In case anyone needs a quick summary on this case, I'm just going to send them here. Next, we have an order for transport. So that'll be nice and quick. They're just going to say, cool, we're going to get Dylan Adams in on May 20th. And remember, we were able to watch that. We watched that testimony. We watched it in November of this year, but we caught it late. We got into this late, but that was really from May of 2025. Then we've got petitioner's updated witness list. So as of May 8th, first on the list, Brett Booth. We've got Joe William Walker, who did not testify at trial. John Walker, that's Marshall John Walker, who did the device tracking. Art Viveros, Terry Dykes, Valerie Trout did not testify at trial. Mark Lewis and Riley Lewis did not testify at trial. Ryan Fletcher, Nicole Weiser. So Nicole Weiser is with the Trial and Error podcast and was present for the Jason Autry recantation. Michael Scholl, so that's Jason Autry's trial attorney. There's a yes/no next to Jason Autry / Ben Harmon. Oh, because they mean no, that Ben Harmon didn't testify at trial. Michael Flanagan, Jennifer Thompson, Jerry Gonzalez, Jim Simmons, Dick and/or Cindy Adams, Rebecca Earp, Victor Dinsmore, Madison County Custodian of Records, Dennis Benjamin, who also didn't testify at trial, Judge Jennifer Nichols, Christopher Boyano, Paul Hagerman, Jim Austin. So that is, I believe, that is Shane's dad. Myra Taylor, Zachary Adams, John Dylan Adams, Paul Dillon. Paul Dillon is the guy that worked with Trial and Error podcast. Or no. Was Paul Dillon the AT&T guy that drove around with U.S. Marshal John Walker? He helped with the phone tracking and elimination. Davis Alberto and Anthony Alexander. So that's their updated list there. And we didn't see all of these people called for these post-conviction proceedings, but that's who they listed. All right, we have an affidavit filed by, let's see, by Jonathan Reeves in support of petitioner's motion for leave to add amendment to post-conviction relief petition. So they want to file this affidavit, and let's see. My name is Jonathan D. Reeves. I am the president of JDR Telecom Solutions. I'm a telecommunications expert with 29 years of experience. I provide technical consulting services to wireless carriers throughout the U.S. I provide expert witnesses testimony related to wireless technologies and cell site coverage and location information. I was previously accepted as an expert witness in the original trial of Mr. Adams and testified regarding various cell phone records and cell tower location and coverage data during the trial. Mr. Douglas Bates and Ms. Crystal Etu contacted me on April 4th, 2025 to discuss my previous testimony and report presented at the original trial. I have reviewed my original report and testimony as it relates to the timelines presented. My review of these records focus on the date and time and possible location of the cellular equipment devices in use by Mr. Adams and Mr. Autry on the morning of April 13th, 2011. I have analyzed the usage records, call and text, between 9:50 a.m. and 10:35 a.m. on April 13th, 2011. Documents, so he's looked at his original report. He's reviewed his original raw cell site data from AT&T at the time of the abduction, and he reviewed original AT&T call and text record data from Mr. Adams and Mr. Autry. So it looks like he's being contracted here to revisit that narrower timeline and look at the interactions between Autry and Zach Adams. So based on the AT&T Tennessee site locations and tower information available, I have modeled an approximation of the predicted coverage for the GSM sites that were in operation at that time. This above modeling and my knowledge of typical GSM wireless communications allows me to provide approximations of the limit where each sector of each tower location could be used for service. So the limitation, as far as it could possibly pick up. The cell records for Mr. Adams and Mr. Autry identify the cell site and sector that was used for the completion of a call or text message. The Birdsong Tower, AT&T site number 084458, has 3 sectors, oriented approximately east, south, and west. Oh yeah, hold on, let me paste this in the chat. And right now, these are all, I'm linking right now to the live links that are still on the Tennessee courts website, because they took down the page, but the documents are still, and it's just easier for me to open them. I hate sharing through Google Docs on stream. It's really annoying. But there is a drive folder. So downloaded all of the files and put them off site. So even if the Tennessee courts pages take down the file uploads, you can still use the drive folder in the description. But yeah, that one is now, actually, did I drop the right one? I think I dropped the wrong link. I might have linked you to the proposed edition. Let me do that again. So this is Jonathan Reeves. So the second link should definitely be correct. All right, so there we go. We've got, where was I? Okay. So the east sector, they're talking about the Birdsong Tower. And again, from the map we looked at, guys, that was all the way in this top corner. Oh, up here. The riprap location. So this is the tower. All right, so we've got, back to the filing. The east sector of the Birdsong site was used by Mr. Autry and Mr. Adams' phones for several calls and text messages between 9:42 a.m. and 10:32 a.m. on April 11th, 2025. April 11th, 2025. Hello? Please have the, okay, so at least we say April 13th earlier in the filing. Yeah, I think it's supposed to be April 13th, but okay. Of 2011. The west sector of the Birdsong site was used by Mr. Autry and Mr. Adams' phones for several calls and text messages between 10:35 and 10:37 a.m. on April 11th, 2025. Therefore, at least as late as 10:32 a.m., Mr. Adams' device had to be located within the service area of the east sector of the Birdsong site, since it had not transitioned out of the coverage area of that sector or cell. So the importance of that would be, I'm guessing, if they're further in this east sector, that's an even greater distance they'd have to travel. But let's see where this might be going. By analyzing the predicted coverage, the known sector azimuths at that time, and applying typical network operational settings, I can provide an approximate maximum area location where these calls would have necessarily been completed within, especially between the unique sector at the Birdsong Towers. The attached maps in Exhibit B and Exhibit C show different colors for each respective sector of the Birdsong Tower and the surrounding sites. The line shown on the map shows the dividing line where the text messages sent by Mr. Adams at 10:32 a.m. would have most likely required to have been northeast of. This dividing line is slightly outside the predicted best server for this northeast sector of Birdsong, identified as cell tower 39077 in the call records, to account for the network operation, which allows some overlap between sectors before reselecting a new serving sector or cell. Note that the south sector of Birdsong 39078 was never used by either Mr. Autry or Mr. Adams' devices on the morning of April 13th, 2011, even though there was only approximately a 3-minute gap after the last record that used the east sector until the first record that used the west sector. This would likely require the devices to have transitioned the coverage area for the south sector within the approximate 3-minute gap in call records. And I think, and this is where, let's pull back up the very early in that motion from Doug. Wasn't he saying something like, it skipped this tower, but there would need to be like 10 minutes. Let's see if we can find where they were talking about this. All right, maybe it was this part. So the time frame and route Mr. Autry testified he and Mr. Adams had driven, namely the winding back road journey from under the Tennessee River I-40 bridge to the point at which Mr. Autry purportedly returned to his PT Cruiser. Yeah, I forgot. They got to go back to the church near Shane Austin's trailer to pick up his PT Cruiser. Would take approximately 32 minutes and require passage through the 39078 cell phone sector, where their phones never registered. Right, so is that where, let's see. Yep, so that's what he's talking about. So note that the south sector of Birdsong was never used by either Mr. Autry or Mr. Adams' devices on that morning, even though there was only approximately a 3-minute gap after the last record that used the east sector. So it should have taken a ping. It would have taken a ping within a 3-minute interval. And so that's why Doug is using this information, this analysis from Reeves to say it's impossible to reconcile Mr. Autry's testimony, and for that matter, Mr. Adams' involvement in the crime with Mr. Adams and the co-defendant's cell phone records. So breaking it down further, the cell phone registered on the northeast cell tower, 1032. Mr. Adams' cell phone registered on the northwest 39079 cell tower at 1035. A mere 3 minutes later, entirely bypassing the south sector of the tower. So upon information and belief, over 3.5 miles of this alleged route would have been covered under Tower 39078 and would take at best 10 minutes to travel. And then Mr. Adams' cell phone then registers on his home tower and sector at 10:38 a.m., another 3 minutes later. So they're getting frequent enough pings or locations. This cell tower sector path in the observed time frame of Mr. Adams' cell phone on the morning of April 13th, 2011 is only possible by interstate travel south to Parsons on I-40. So the back roads theory cannot be true. Which is, remember, Jason Autry not only testified to this, but during his proffers, he went on a drive to take the state's agents through his quote-unquote route the day of the abduction. All right, so let's see. Oh, I think I went too far down. So therefore, the south sector was never used. This would likely require the devices to have transitioned the coverage area for the south sector within the approximate 3-minute gap in call records. Therefore, the original data, as well as my report and subsequent predicted model approximation of the coverage area, all support Mr. Autry's and Mr. Adams' devices being north of the dividing line, depicted on the attached exhibits B and C before 10:35 a.m. on April 13th, 2011. Oh my God, this is hard to look at. So this is what they attach. So here's the dividing line running. You can see my mouse on screen, right? Yeah, so this is the dividing line running here. And zooming out, we have over here, this is the Adams residence. So Birdsong Bridge, Adams residence, Austin residence is down here. And then again, you have to scroll all the way down to see where Holly's residence is. So what's his expert analysis here? His expert opinion is based on my analysis. It is my expert opinion within a reasonable degree of telecommunications analysis certainty, very specific certainty, that between 9:50 a.m. and 10:32 a.m. on April 13th, 2011, Mr. Adams' device was located northeast of the dividing line, shown on exhibits B and C attached here too. Had Mr. Adams' device been within the coverage area of the Birdsong area on a different sector/cell, these calls would have been initiated on a different sector or cell. It is possible that Mr. Adams' device could have been located anywhere within the actual coverage area of this east sector of Birdsong during this time, but it would not have been possible for it to be located outside of the coverage south or west of the provided dividing line. So, because the Birdsong tower location has multiple sectors at known orientations or azimuths, it is possible to determine an approximate dividing line between these sectors and where devices will utilize the coverage from each sector. Factoring in the typical network selection parameters allows for some overlap when devices travel between sectors. The dividing line shown on exhibits B and C accounts for this network selection allowance. In conclusion, so based on my analysis, it's my conclusion that Mr. Adams' device was most likely located northeast of the dividing line shown on the exhibits B and C between 9:50 a.m. and 10:32 a.m., April 13th, 2011. So there we go. And I think this is stupid, but that would also mean he couldn't be the one driving down that right side spoke of this map going down to these locations. So, which the state tries to reconcile by saying, well, Dylan was running his errands for his brother to get rid of the cell phone. So he signs it. And there's his curriculum vitae, and then there was the maps below. So yeah, I think page B, I think this is a part of it. They were all like, this was in 2011. We didn't have cell phones back then. I think there might have been a little bit of, I don't know, looking at, the jury might have looked at this like it was what CSI shows purported to be able to tell back then. I don't know. So there was that. We have notice of objection to somebody's subpoena for documents. All right, Michael Scholl. So, attorney for Jason Autry at the time he gets the discovery folder and starts playing ball with the state. He says, hey, I'm objecting to the subpoena issued on April 29th by, I think petitioner requested it. I don't think the state wanted it. Said subpoena is seeking information from counsel concerning his former client, Jason Autry. Counsel would submit that all documentation and testimony sought by the subpoena is covered by the attorney-client privilege and work product, which has not been waived by counsel's client, Jason Autry. Counsel has been subpoenaed to appear in this matter on May 21st, 2025. Counsel has multiple other court appearances in Shelby County that day. I'm sure, there's some, doesn't Wyrick work over there? I wonder if they loaded up his calendar that day. Make it so you can't be there. Including an appearance in federal court for the Western District of Tennessee. As part of this objection, counsel states for the record that he never received an offer of settlement in the state of Tennessee v. Jason Autry prior to Mr. Autry's testimony, nor was counsel promised anything for Mr. Autry's testimony. I mean, maybe put that in an affidavit. But okay. The state would scream if this wasn't helpful to them. The state would be like, but you need to put it in an affidavit. Lastly, counsel has searched his records and can find no documents which relates to this subpoena. If the court were to compel the testimony of counsel, counsel would request under the current law that his testimony be taken by deposition. So there you go. All right, petitioner's second updated witness list. Do we see any names that they added? Maybe they just do it at the end. They add Kathy Ferguson. So they added Kathy Ferguson, Bradley Strawn, and Mike Smiley. And I wonder if we added Kathy Ferguson 13th of May. Maybe not. But it was interesting because Kathy Ferguson sat in on these post-conviction hearings and got to listen to all the testimony before she actually went up a few months later. All right, so states now we're getting into stuff that we did talk about back in November when we first dived into this case. So these were the state's motions in limine. It says it was submitted on May 15th. So we're not going to read these in depth, but they should explain themselves. Motion to exclude the Jason Autry video interview recorded on December 22nd, 2023. This one's going to be granted. 2, motion to exclude evidence not provided under Rule 16, reciprocal discovery. Bradbury said he's going to take it under advisement, but meaning like okay, it says it lost screen share audio. You can hear me, right, guys? StreamYard's doing StreamYard things again. All right, let me remove myself and the screen real quick. I'll be back in 1 second. All right, I don't know if we'll need to share screen audio or if mine wasn't working, but StreamYard had a big red error on it, so now it's gone. So, anyway, back to this motion limine number 2. The judge was like, all right, well, they should be, you know, as a courtesy, giving you discovery as appropriate. I don't see issues right now. It was a reserve ruling. If it becomes an issue, obviously, I'm not going to say they can refuse discovery, but it wasn't an issue at the time, a specific issue at the time. And then motion to exclude any evidence or testimony of polygraph testing, voice stress testing, or results. The judge granted this. So, all right, so state's response to Petitioner Adams' motion to release Katie Spirko from state's witness list. Because remember, they had her under subpoena. Subpoena goes away. Then they add her to the witness list to keep her sequestered. So she can't be on the podcast talking about why this case is stupid. So comes now the state of Tennessee by and through the undersigned attorneys and files this response to Petitioner Adams' motion to release Katie Spirko from the state's witness list, or compel the state to call her as a witness if sequestered, and in support thereof. I didn't catch this, but that's hilarious. So, Zach Adams' motion wasn't just to release Katie Spirko from the witness list. They said, or make the state call her. Go ahead. Put her on the stand. They said, alternatively, we want the court to compel the state to put Katie Spirko on the stand. And the state says, no. So you're forcing the state to reply and admit that your ultimate goal isn't really to call Katie Spirko as a witness, which would mean what? You're putting her on the witness list for what other purpose? So they're going to say, in support here, Petitioner Adams does not have standing to make this motion and it should be denied accordingly. In the alternative, it is not possible to know what Petitioner Adams' witnesses will testify to at the hearing. Given Katie Spirko's evolving titles and roles in this case, there are several scenarios that might trigger her memory. Oh, wouldn't you know a lot about that, the state? Wouldn't the state know all about this? There is no authority for Petitioner Adams' request that the state be compelled to call her or anyone else as a witness. Yeah, it was a funny quip that went over your head because it was calling you out on exactly what you're doing here. So wherefore, premises considered, the state of Tennessee would request that the Honorable Court deny Petitioner Adams' motion to release and or compel and for any other general relief. So that's hilarious. That is hilarious. Let me close some tabs. I think I've got everything open that we've looked at so far. All right, so... All right, May 15th, State of Tennessee's response to Petitioner Adams' motion for sanctions. And unfortunately, I don't think I remember reading this. And again, there's been some things that just haven't... Maybe I skipped this one. All right, so I did skip this. So I missed this. So let's go back to May 2nd. This is the petitioner's motion for sanctions, and then we'll read the response. So we want this court to sanction the state of Tennessee by all matters within its discretion for its handling of the exculpatory evidence of the ATM machine in this case. The petitioner relies upon the contemporaneously filed proposed amendment for the facts asserted, which is briefly summarized. The state obtained the actual ATM machine and or recording software within the same on May 12th, 2024 under... Oh, wait, I think we did read this. No, we didn't. Under powers authorized to the TBI to, quote, investigate crimes. Only when the state was advised that counsel knew of this subpoena and machine did it reveal it had this machine. Counsel tried to obtain this subpoena for months, both informally and through a formal motion to compel. Only during the last week of April 2025 did the state even provide this investigatory subpoena. Petitioner submits that the state is unable to claim there is an investigation happening in this matter, while also demanding that Mr. Adams' conviction not be disturbed. Pursuant to Lindsay v. Allen, the, quote, investigation period of this case ended at the trial. Further, this evidence was only exculpatory evidence, and thus the state's conduct should be scrutinized heavily in how they have handled this evidence. So the prejudice should be assumed. Further, the state should be judicially estopped from litigating in this post-conviction relief case that stakes a claim that the petitioner's conviction should not be disturbed, but then treats the case as if there is no conviction. Sparingly granted in civil cases, judicial estoppel in criminal cases, if even available, is rarer still. So United States v. Levasseur, that says, leaving open the question of whether judicial estoppel may ever be invoked against the government in a criminal case. United States v. Layman, same. This is hardly surprising, as the Sixth Circuit has often remarked that judicial estoppel should be applied with caution to avoid impinging on the truth-seeking function of the court. And that's White v. Wyndham Vacation Ownership. Judicial estoppel generally prevents a party from prevailing in one phase of a case on an argument and then relying on a contradictory argument to prevail in another phase. Hilarious. Although, who even thinks to, file this? Although there is no set formula for assessing when judicial estoppel should apply, it is well established that, at minimum, a party's later position must be clearly inconsistent with its earlier position. So, it is an equitable doctrine that preserves the integrity of the course by preventing a party from abusing the judicial process through cynical gamesmanship, achieving success on one position, then arguing the opposite to suit an exigency of the moment. The state provided no investigative reports in discovery to the petitioner, because there's no investigation. It is believed that the state is probably still relying on this, quote, investigatory subpoena to subvert the narrow strictures of Tennessee Superior Court rules and Rule 16, which is respectfully acting in bad faith and against the orders of this court. To address all of this, the petitioner would request, 1, to sanction the state on how they have handled the exculpatory evidence in the ATM machine. This includes all form of relief, including granting of the post-conviction relief claim. 2, to compel the state to provide all subpoenas of all kinds they have issued in this case, and until proper examination, and preserve the request to quash and destroy and/or preserve and provide to Dylan Adams and Zachary Adams the exculpatory evidence they are obtaining for the potentially forthcoming new jury trial on the merits, for such further and general relief to which the petitioner is authorized. So that was their motion that I skipped. And then we have their response to the petition for sanctions. Same, GV. So comes now the state of Tennessee, and they filed this one quickly. They did it on May 15th, and the motion for sanctions was filed on the 2nd, so they didn't wait. So they say, the state requests said motion be denied, and in support thereof submits the following. Opposing counsel omits relevant information from his motion. Petitioner Adams' trial attorneys received an external hard drive from the state on June 15th, 2015. Yeah, maybe the one she said she couldn't access. Jennifer Thompson acknowledged receipt of said hard drive. See attached Exhibit A for signed receipt. This hard drive contained, among other views, from the bank's cameras, the view of the ATM line and the image at issue in petitioner's motion for sanctions. It is disingenuous at best and misleading in the worst light to call the video exculpatory. Chat. Do you think that ATM stuff is exculpatory? Oh my gosh, this is going to give me wrinkles reading this. So they say it's misleading in the worst light to call the video exculpatory, using that word repeatedly as opposing counsel does, and does, not make it so. What is visible on the video is the following. A truck. Nothing or no one is identifiable inside the truck. There are no unique identifying or distinguishing marks on the truck. That's not true. It is simply a video of a truck at the ATM window. A video of a truck that petitioner's trial attorneys received on June 15th, 2015, and that post-conviction attorney received from Jennifer Thompson in the fall of 2023. The timestamp on the video is April 13th, 2011 at 11:12 a.m. Neither the defense nor the state utilized this video at trial. On January 22nd, 2024, Katie Spirko filed a declaration with the court along with her curriculum vitae outlining her work in neuropsychology and false confessions. She further advised that attorney Doug Bates discussed retaining her to review any particular evidence regarding inmate Autry's testimony and provide appropriate perspective. In the months following that filing, the state became aware of actions by Ms. Spirko that did not seem consistent with an expert in neuropsychology. The state learned that and this is all after the judge has said, drop the Katie Spirko issues. We read that bullet point list of his orders. This is after all of that. So the state learned that Ms. Spirko video recorded a conversation with inmate Autry and sent said conversation to ABC News 2020. Ms. Spirko misrepresented to the Shelby County Division of Corrections the reason she needed to bring in a recording device. Counsel for inmate Autry had not been informed of the meeting between Autry and Spirko, and counsel was forced to withdraw his representation because of the recording. Janet Britt executed an affidavit on April 11th, 2024, that Ms. Spirko visited her and advised that Terry Britt, Janet Britt's spouse, will be charged with the murder of Holly Bobo, and that Janet Britt could be charged as an accomplice. See Exhibit B for Janet Britt affidavit. This isn't an accurate reflection of what happened in that conversation, but okay. Ms. Spirko visited Lisa Sanders under the guise of working to obtain Jason Autry's release from prison. And I think Katie said that they, like, initially when they were, I think it was like episode 4 was the Terry Britt episode. So if you go back to episode 4 of the Trial and Error podcast, it's all about Terry Britt. And they've got these tools that they have, the dogs had a hit on, and they've got these different vans, and they've got these recordings where they wiretap the home, they're listening to phone conversations, and there's this part on the recording where Terry Britt is excited that they're not going to find anything in the old van, and specifically only says that they're not going to find anything in that one van. But the state will then end up saying, well, that's exculpatory for Britt, because he's aware they're not going to find anything. He's clearly not worried that they're going to find anything. It was just such a weird... You just got to watch that episode. It's just such a weird... The whole rundown with the Brits is bizarre. And then that was the first video where I heard of there's this rope in the back of the other van that has a blonde hair. And at trial, they're going to say it was excluded from being Holly's, but it wasn't. They only did the type of testing that can narrow it down to like 25%, and Holly's hair color falls within that 25% that they did. They never actually did like a root analysis of the DNA. So there's just a lot. But they did a great job with that episode. And again, I don't think it's even necessary for Terry Britt to be like some new evidence that Terry Britt's the one that did it to warrant a new trial. I think all of the other issues alone are enough. But this Britt stuff blows my mind. So we've got Sheriff Chuck in the building. Says, why did one of the state's DAs have that truck up on their laptop during the hearing? What would he have it up if it was just a truck? Good question. It's just a truck. Just a truck on my screen. And it's really telling. And again, just the kind of thing that happens in a courtroom that if you read on the record, you might not be able to ascertain. But we've gotten to hear that Zach Adams sees the truck on the screen and goes to Doug, that's my truck. So apparently at a distance, he can identify that that's his truck. He can identify that that's his 2006 Chevy Silverado. But yet the state's like, even when we can look at the file straight on, it's only a truck. There's no distinguishing features. And I wish I had, I only have like a cropped picture. It's not very good. But these like markings here, I think it's so disingenuous for the state to say there's no identifying features on what's visible here in this picture. I mean, there's a lot. The shape and color of the door handles, the size of the cab, the tint on the back window, which sure can be changed, but maybe if that's how the manufacturer makes it, that's telling. This type of molding, this footstep, the way this footstep's set up. Maybe these are rims from the manufacturer. You really are going to sit here and tell me that a state prosecutor doesn't think that there's any important details that could be... If they needed this picture to incriminate, if this was a picture of like outside the Ring camera the day Holly was abducted, and this is like a picture from the driveway of the truck. You really mean to tell me that the prosecutors would tell you they can't tell anything from this picture? Yeah, and also don't forget, something distinguishing about it was that it was going backwards, and that Zach Adams had said that they drove backwards through the ATM. So, and not for nothing, but I mean, I can at least see that there appears to be somebody in the back seat. Yeah, Marissa Tomei could confirm it. Yeah, and this is the thing. This is the grocery shelf, right? Oh yeah, plus that. Like, there's just so much. I cannot fit all of I cannot fully stock the shelf with all of the things that make this case crazy because stuff keeps falling off. There's too much to keep track of. And Trikisha, question of the day, how do they convince themselves? Because they would absolutely use this picture to incriminate somebody if this picture was taken at the scene of a crime. They would say, we can tell enough here. We can see all that we need to see. This is clearly this truck. They would argue to the jury that, you know, the cell records also put them there. And a defense attorney would have to get up there and say, well, you can't really see all of the details of this truck. And just because all of their phone devices were located here, that only shows you where the devices were, not that they were holding their phones, right? So it's just a total role reversal. Total role reversal. And again, having the wrong guys means the right guy is not convicted. So it just bothers me. It bothers me a lot. So anyway, back to their, where was this? Let's just read this one more time. There's nothing. What is visible on the video is the following. A truck. Nothing or no one is identifiable inside the truck. There are no unique identifying or distinguishing marks on the truck. It is simply a video of a truck at the ATM window. Backwards. A video of a truck that petitioners and trial attorneys received on June 15th, 2015. Like, okay. Oh my gosh. So anyway, back to the complaints about Katie Spirko. And it's just like, I don't know. I'm not saying, like, if this were true, like, I still don't even really see how this would be such an issue. I see this more as the state wants to make sure that nobody is allowed to go and talk to the Brits because they're scared. Miss Spirko visited Lisa Sanders under the guise of working to obtain Jason Autry's release from prison. Counsel for Petitioner Adams advised, well, not really under the guise. I mean, I guess I would like to see more of that just to see what that was, but in the recorded conversation with Jason Autry, Katie Spirko was clearly speaking to Jason Autry from the perspective of, you know, this is helpful to the petition. And thus, if the theory of the case that got Zachary Adams convicted was these four guys all did this thing together, of course there's going to be a logical carryover. Anything that might go to exonerate Zachary Adams could and very well should go to exonerate Dylan and Shane, since they're also in the Parsons truck. But in a way, it also goes to exonerate Jason Autry, at least for some parts of the timeline. So sure, there's a carryover. So there was some mention from Katie Spirko about acknowledging that Jason Autry didn't have anything to do with this. I don't think it was misleading at all, the purpose for which Katie Spirko was there talking to Jason Autry. And not for nothing, but the state should also reiterate, they've told us in 2 different motions already, that Jason Autry was telling Lisa, hey, this is my chance to fuck the state for fucking me over in my federal case. So, Counsel for Petitioner Adams advised the court that he had concerns about Ms. Spirko's tactics and methods and was no longer utilizing her services on this case. One of the reasons cited by Mr. Bates was that Miss Spirko planned to meet with Dylan Adams without counsel and without counsel's permission. TBI agent Kathy Ferguson then heard a prison call between Ms. Spirko and Petitioner Adams, in which Ms. Spirko claimed that there was bank footage that cleared Petitioner Adams that TBI refused to get. Given Agent Ferguson's knowledge of this case and the work done by Loan Me, I just saw my StreamYard flicker. Did it just... I have a red error again. So this is week 2 of StreamYard throwing errors. And I think something similar happened with Take It to Trial last night, that it only fixed when she pulled herself down and went back up. So not a her error, not a YouTube error. I don't know what it is. Let me do the remove and come back in a second, guys. All right, so everything should be on the screen. Although now it thinks I'm sharing 2 things, but all right, who knows? So, based upon her investigation and out of abundance of caution, TBI issued 2 administrative subpoenas to the bank. May 7th, 2024, for DVD. Oh, so this is why they're doing it. This is why they had to run and get that ATM. For DVD labeled 4/13/2011 and on May 13th, 2024 for recording devices used by Citizens South Bank, Community Bank, and or CB&S Bank in Parsons, Tennessee on 4/13/2011. Why would they request additional stuff? And how could this be blamed? How could this be blamed on Dr. Spirko? Because what would Dr. Spirko have done between the sneaky subpoena where you're not supposed to talk about it? It would seem more logical that the state reviewed something and were like, oh crap, let's look and see if there's more. But okay. The return of said subpoenas yielded the identical recording provided to trial attorneys in 2015 and referenced in paragraph 1 of this response. Based upon the state's growing concerns, and they have not been able to inspect this device themselves. So the petitioners, Zach Adams' team, have not been able to go. This is only their word. Based upon the state's growing concerns about Ms. Spirko's conduct, her unclear role in this case, and opposing counsel's own statements about her, the state felt obligated to secure this information, protect it, and ensure that all parties have access to it. TBI mirror image copied and provided to petitioner attorneys on August 26, 2024, what they received from their administrative subpoenas. See attached Exhibit C for signed receipt. Petitioner cites Lindsay v. Allen as authority for the idea that the responsibilities of the state of Tennessee and at conviction of a criminal defendant. Lindsay does not hold that, and nothing could be further from the truth. To take petitioner's argument to the illogical conclusion it presents would mean that prosecutors would sit quietly by at all post-conviction proceedings, resting on their laurels of a conviction. Our duties never stop. This is very much the Brent Booth, this case haunts me. Why does it haunt you? Long hours. Our duties never stop, both in protecting valid convictions and preventing abuse of the judicial system. We, unlike any other category of attorneys, are ministers of justice. We must and do act when faced with valid, reliable information pointing towards an accused's innocence. We likewise must and do act when confronted with those. Yeah, but the actions you took seem to have been to hide and suppress it because somebody was changing file names. So you did act, but you acted in a way to preserve the conviction and pathway to getting that conviction. We likewise must and do act when confronted with those whose motives are not aligned with seeking truth, or people that get in the way because they're seeking the truth and they're walking down a path that would go against your grain, like Viveros, U.S. Marshal John Walker, Terry Dicus. The Lindsay decision cited by petitioner is a contempt of court case in Chancery Court, interpreting an act to preserve the purity of elections. At issue was whether individuals could be forced to testify regarding contested elections and what consequences the statute allowed for refusal to testify. Petitioner has been provided the investigative subpoenas issued in this case by the state of Tennessee. So wherefore, yeah, late. What was the date? When did they finally turn those over? Let's see. Yeah, April 2025. So like 2 weeks before they're filing this response. 3 weeks. Even though they were using the subpoenas in May of 2024. Notice how they don't put the date there. They just say, although they've been provided. Let's not mention that it was a year late. So, deny petitioner's motion to release Katie Spirko from the witness list or compel to call her. Yeah. Sweet. Where were we next? Was there anything attached here? Hold on. Okay, so this is them when they signed off. We're sending you the discovery. Are you going to get emails? The affidavit of Janet Britt, which we've read previously. The hard drive, so we've seen this already. Given to Bates. There we go. Nothing new in those attachments. And then, let's see. Okay, wait. So we read the response to the motion for sanctions. We read the response. The next would be this motion for leave. All right, so State of Tennessee's response to Petitioner Adams' motion for leave to add amendment to post-conviction relief petition. The state would state as follows. The state highly disputes Petitioner Adams' stated reason that the ATM video, which Petitioner Adams' trial counsel obtained possession of in discovery in June 2015, and Petitioner Adams' post-conviction counsel has had in his possession since fall of 2023, is newly obtained information warranting the filing of a 30-page amendment on the eve of this hearing. Spoiler alert, guys. Judge Bradbury is going to allow the amendment to this petition. We've talked about that previously. They allowed it, but this is the state arguing against it, desperately flailing. Do I need to do the little flaily arms? I think we need some flaily arms. So, however, the state is not asking the court for a continuance and stands ready to proceed on May 19th, 2025. If this court allows Petitioner Adams to add the amendment to his post-conviction relief petition, the state would state that all allegations contained in the amendment are denied, and the state demands strict proof thereof. So there's Amy Wyrick signing off. And then moving on, we are now moving to May 22nd. So by the time of May 22nd, there's been a few days of hearings. All right. So order on the state's motion to exclude Jason Autry's video interview. I think we read this on stream as well previously. Because while we were watching the May hearings, you guys were like, hey, do you know what happened with that? And that was the first time we really looked at some of these motions, these filings. So they're going to say that, long story short, well, let's just read it. It's only 5 pages. Before the court is a motion in limine filed by the state on May 15th to exclude from evidence at Mr. Adams' post-conviction hearing a video recorded interview dated December 22nd, 2023, between co-defendant Jason Autry and Dr. Katie Spirko, a neuropsychologist hired by counsel for Mr. Adams. During the interview, Jason Autry claims his September 2017 trial testimony was false. In a response filed on May 17th, the petitioner argued that Mr. Autry's statement is admissible as a declaration against interest from an unavailable witness under... So that wasn't... This that's being referenced here is not part of the files that were uploaded. So again, we're missing... I'm glitching? Oh no. Oh no. This is stupid. Come on, StreamYard. We're going to try one more time. We're going to boot me. I'll be right back. All right. Oh, okay. Maybe defense diaries was behind. Okay. Well, in any case, might as well make sure because I don't know. It seems to be related to the sharing of the tabs. It just starts freaking out. And that's never really been an issue in the past, but it's been an issue like 10 times in the past 2 weeks. All right. So again, we don't have this filing. It wasn't up there. But guessing from this, Doug Bates was trying to say, hey, it should be admissible as a declaration against interest from an unavailable witness. On May 19th, 2025, before the commencement of the evidentiary hearing, this court heard argument on pending motions, including the motion to exclude Mr. Autry's video statement. And they're citing the 19th, the hearing on the 19th. The videotape statement was received as an offer of proof to the post-conviction hearing and marked as Exhibit 1. The state acknowledged that Mr. Autry was unavailable because, after the appointment of counsel, he filed a notice with this court stating his intent to invoke his Fifth Amendment right against self-incrimination. This notice included a statement of intent not to waive any other rights or any privilege with his prior counsel. That was the notice of intent that we read from Jason Autry. The state argued that Mr. Autry's video statement was inadmissible hearsay, and the hearsay exception for statements against interest was inapplicable. Specifically, the state contended that the statement itself was not perjurious. Mr. Autry could only be subject to prosecution for perjury if he took the stand and testified to the truth of the statement. Further, to attack the reliability of this statement and the credibility of Mr. Autry, the state produced Mr. Autry's subsequent assertions on recorded telephone conversations that he was high on drugs at the time he spoke with Dr. Spirko, and that he made the statement as a means to get revenge on the state. The recorded calls were entered into evidence at the post-conviction hearing as Collective Exhibit 2. The petitioner's counsel asserted that Mr. Autry's statement is inadmissible as a statement against interest because the statement is inconsistent with representations he made in a federal court plea agreement, and therefore it subjects him to prosecution for perjury. And they're citing here the state's motion requesting the court to appoint counsel for Jason Autry, an exhibit that they included. Counsel referenced the state's request for an attorney for Mr. Autry as proof that the statement placed him in legal peril. In addition, counsel argued the statement was important because it indicated that, at the time of the trial, Mr. Autry was a state agent and he testified falsely. Considering all the circumstances, this court granted the motion for the reasons stated from the bench on the 20th. This court's supplemental ruling follows. Mr. Autry's video statement is hearsay. It's an out-of-court statement that the petitioner offers is true. The hearsay exception for a statement against interest provides a statement which was at the time of its making so far contrary to the declarant's pecuniary or proprietary interest, or so far tended to the subject, the declarant, to civil or criminal liability, or to render invalid a claim by the declarant against another, that a reasonable person in the defendant's position would not have made the statement unless believing it to be true. So this would be the idea that, what does he have to gain by telling the truth in this December 2023 recantation? He could only face penalties. He'd be at risk of the state saying, hey, you went back on what you agreed to as a term of the plea deal that we gave you. And you've got this other prosecution looming over your head. Conversely, the state was saying he was doing it for his own gain. He wanted some personal get back at the state because he's facing these other charges. So here, Jason Autry is unavailable because a statement against interest is admissible if the declarant is unavailable. Here, Jason Autry is unavailable because he asserted his Fifth Amendment right against self-incrimination. On April 11th, 2025, counsel for Mr. Autry filed a notice of intent wherein Mr. Autry asserts all protections afforded to him under the U.S. Constitution and Tennessee Constitution. Additionally, this court finds that Mr. Autry is unavailable under Rule 804A5 since he is absent from the hearing and petitioner's counsel has been unable to procure his attendance by process. In February and March of this year, the petitioner attempted to subpoena Mr. Autry to court. The Federal Bureau of Prisons refused to transfer Mr. Autry without a request and documentation from the state. The state declined to provide this information. And they're referencing, when we read that, their response. Accordingly, Mr. Autry is an unavailable witness. This court has viewed Mr. Autry's video statement Considering all the circumstances, this court finds that the statement does not so far tend to subject Mr. Autry to civil or criminal liability that a reasonable person in his position would only make the statement if they believed it was true. First, the environment in which the statement was made does not have the indicia of solemnity to provide notice to Mr. Autry of the gravity of, or any consequences from, his statements. He begins the video laughing. The video depicts Mr. Autry speaking casually with an agent of the petitioner, Dr. Katie Spirko. He did not express any genuine reservations about talking with Dr. Spirko. He said his incriminating trial testimony was untrue. He did not provide an alternative account of his actions or those of others during the time surrounding the crimes against the victim. This statement was not made to law enforcement or a member of the prosecutor's office, which would impress upon a reasonable person the possibility of legal consequences. All right, so I agree with the judge's ruling, and this is a side story, but it's interesting to read this right after the state is putting weight in what Katie was allegedly doing to threaten Janet Britt. So I feel like the state, I'm not disagreeing with the judges, how he's analyzing this, but if you put this side by the state would characterize what Katie Spirko is doing as impressing upon the people she's speaking to that they're facing prosecution or other legal consequences. So it's just funny to see the judge say, no reasonable person would think that about Katie when we just read the Janet Britt affidavit motion thing. Mr. Autry, and also, what about Dennis Benjamin going to Victor Dinsmore and saying, you're facing 8 counts. I'm talking to Jack Van Hoosier. Mr. Autry did not attest to its truth. The statement was not made under any oath or vow of honesty. Mr. Autry did not attest, and I think this is really critical for this ruling. Mr. Autry did not attest to its truth in the video, nor subsequently subscribe in writing to the truth of the statement. So because there was no affidavit, and we're not getting him on the stand here, we can't fix this problem now. When he spoke with Dr. Spirko, Mr. Autry's date sentence for crimes associated with the instant case had expired. This court questions the reliability of the statement. This court finds that the circumstances do not tend to show that Mr. Autry, or a reasonable person under the same circumstances, would have believed the statements were incriminating to the extent that they would not have been made unless they were true. Furthermore, even if the statements were perjurious, any consequence would pale in comparison to the unrelated federal term of imprisonment Mr. Autry is currently serving. This court finds that any criminal sanction resulting from the video recorded statement would not have deterred Mr. Autry from lying, as contemplated by Rule 804b3. Second, the statement's content alone is not incriminating. It does not provide sufficient evidence for the prosecution to use in proving any criminal charges. Generally, Mr. Autry asserts that his trial testimony was untrue. He claims his testimony was fictional, a story he conceived based on pretrial discovery documents. The petitioner has not shown or cited any inculpatory statement in the video. So they're arguing here like what he's saying here wouldn't be incriminating for himself in relation to this transaction. So this footnote says a court must examine each assertion in a hearsay statement to determine whether it is inculpatory. He simply asserts that the statement is a recantation of Mr. Autry's trial testimony where he had admitted to assisting the petitioner dispose of the victim's body. Yet, a recantation is not a statement against one's interest. Mr. Autry's assertion that he concocted his trial testimony tends to exculpate himself or minimize his criminal conduct. This court finds Mr. Autry's video statement is predominantly self-serving, and at the least, it is not against his penal interest. So that's why we have a distinguish, like, hey, we don't think it's against his interest in relation to the consequences he's dealing with related to other cases. And then we break down, we do the analysis for as it relates to the Holly Bobo case. So finally, Mr. Autry's subsequent actions undermine the reliability and veracity of the videotape statement. He stated that he was under the influence of drugs when he spoke with Dr. Spirko. And that's referencing, I'm assuming, the conversation with Lisa. So, let's see. Did I skip a footnote? Okay, I skipped this footnote. So footnote 7 about the court finding that Autry's video is predominantly self-serving. Most self-serving statements are excluded not solely because they are self-serving, but instead because they constitute inadmissible hearsay. And then footnote 8 was Exhibit 2, the post-conviction hearing, the 3 audio files, and transcripts. So those are those Lisa Sanders calls where he said he was doing it to F the state. He also admitted he made the videotape statement as revenge against the state of Tennessee. Finally, he invoked his Fifth Amendment privilege against self-incrimination when informed of the possible consequences of testifying under oath to the videotape statement. His subsequent actions when his attorney confronted him with the possibility of criminal liability contrast with his free-flowing conversation with Dr. Spirko. The totality of this, and I mean, I would read this in the opposite direction personally, but the totality of the circumstances leads this court to find that Mr. Autry's video statement is not a statement against interest. Without an applicable exception to the rule against hearsay, this court cannot admit the statement into evidence. So wherefore, they grant the state's motion to exclude Jason Autry's video interview. We're moving along. This was permission. Zach Adams' team asked for a certificate of immediate review. They wanted to do an appeal, interlocutory appeal on this ruling on the video, the recorded interview of Jason Autry. So they grant it. So further, to the extent the petitioner plans to present proof unrelated to Mr. Autry's statement, this court will not stay the post-conviction hearing pending resolution of this appeal. So they're going to keep going. So they find that it's appropriate. And then this appeal was denied. So the appeals court affirmed Judge Bradbury's decision to grant the state's motion in limine and exclude this video. Then on June 3rd, this is where we have the block. So we don't need these January dates anymore, it looks like. It looks like these are going to be off the table. But we're here. We're going to be here starting on Monday, December 29th and 30th. We have order granting petitioner's motion for leave to amend. So remember we said earlier, hey, like the judge is going to allow them to add this 30-page amendment with all of the ATM, the phone data, the timestamps. So court granted this motion from the bench on May 19th, 2025. And then let's see. He says that the rules of post-conviction procedure allow liberal amendments to a post-conviction petition. The court finds it's appropriate to grant the motion to amend, and the proposed addition will be considered on the merits with the petitioner's pro se, second amended, and supplemental petitions for post-conviction relief. So, and then the orders on motions 2 and 3. So this is where we deny the other 2 motions in limine. So about the stress testing, and the polygraph tests. So I guess we can just read it. It's 1 page. So they addressed this motion from the bench on May 19th, but we're writing this up now. Motion 2 was to exclude from the evidentiary hearing evidence not provided as reciprocal discovery under Rule 16. Counsel for the petitioner stated that reciprocal discovery had been disclosed in full, with a possible exception for a developing matter. They said, see petitioner's response to motion in limine 1 through 3, filed May 19th, 2025. This court determined that it would address the admissibility of subsequently arising or undisclosed facts, if any, at the time they occur. Motion in limine 3 was to exclude from evidence any evidence and testimony regarding polygraph and voice stress testing and results. Counsel for the petitioner stated such evidence would not be introduced during the hearing. See petitioner's response to motion in limine 1 through 3, filed May 19th, 2025. So this motion's uncontested. So wherefore the court's reserving ruling on 2 and grants on 3. All right, this interlocutory appeal. We are now on June 6th. So it's just saying that it's initiating it. And then on 6/13, interesting. So this was actually from May 13th, but the Tennessee website, because I just copy and pasted this. This is how they had it written. They had this listed as June 13th, but that might be why we didn't see it earlier. So But this was, so we're going back in time. Now we're 13th of May. But this was the motion to release Katie from the state's witness list. As Sheriff Chuck releases 5 members of the chat from the gray list. Thank you, Sheriff Chuck, gifting 5 memberships. And I'm sorry. Okay. Did my mic just cut out for you guys for a second there? I've got to switch away from StreamYard because this is getting crazy. Or maybe it's like, you know, extra funky because I switched my desk and had to replug everything back in. But it was doing it last week. Anyway, I was saying, I know that there's blue water. I know that those are green rubber ducks, but to me, it just looks like we've got Chuck Norris in a bush. So that's just how my eyes are going to forever see this picture. So thank you, Sheriff Chuck, gifting 5 memberships, getting us through, turning us green. Yeah, that was weird. It was like as soon as I pulled up the super chat, I saw a red error and it said the browser lost connection to my microphone. And all I had to do was toggle my audio on and off on StreamYard and it worked. So, sounds like a StreamYard issue again. But thank you, Sheriff Chuck, releasing 5 members from their subpoena. You are no longer on the state's witness list. You were on the green list. Big thank you here to Sheriff Chuck. I don't know what it's doing. I don't know what StreamYard's doing, but probably something like this. So, let's see. Their request was Dr. Spirko worked from the beginning of the case as an agent of petitioner's counsel. She then became an agent of the petitioner and his family and has remained so throughout. Dr. Spirko's expertise, so we heard Cindy Adams, so that's probably the family member, maybe more family members. Dr. Spirko's expertise in neuropsychology was initially anticipated to serve as a foundation of possibly being a testifying expert in this case. However, based on a variety of circumstances, it was determined that she would not be a testifying expert for the petitioner. Accordingly, the petitioner has never anticipated calling either a factual or expert witness. And I'd say a lot of this would be if you can't call Jason Autry, that'd be one of the main people to use it to want this type of analysis on. The state advised in March of 2025 that they were not calling her as a witness. The state initially filed a lengthy list of potential witnesses that listed over 600 names of potential witnesses. Dr. Spirko's name was not listed. Isn't that funny? The court asked for a more realistic witness list, and the state provided one that included Dr. Spirko. It is highly doubted that the state truly wishes to invite Dr. Spirko to the witness stand in this case, thus opening her for cross-examination by the petitioner on any relevant matters that could include certifying her as an expert in her field and as applied in this case. Thus, it is suspected the state mainly wants her to be sequestered to limit her knowledge of the case being provided to petitioner during the trial breaks. Further, it is anticipated that this is an effort to limit any further dissemination by Dr. Spirko through her media outlets. While petitioner's counsel takes no petition on the value and virtue of any publicity on this trial bench, the state should request a protective order instead of abusing the rule of sequestration. Thus, the petitioner would request the state, as officers of the court, to state that they are in fact calling Dr. Spirko as a witness, and the court to compel them to stick to this approach, or alternatively, release Dr. Spirko from the rule of sequestration, as she's not going to be a witness in the case. So unfortunately, no update on that until Monday, Tuesday. We'll see if they call her or not. And if, when all said and done, obviously there's no need for a witness list, that will finally be lifted. And then the last thing here, guys, was unavailable. It was an order denying petitioner's sealed motion to unseal statements of Michael Scholl. So we made it through the available documents for the post-conviction petitions. So that was a great time. I feel like there was a ton of context. I really enjoyed reading this proposed edition where Doug was laying out the timelines. Like seeing that in writing. Like his opening, when we rewatch his opening, is going to make a lot more sense. So, let's see. Okay, Riggs says Bradbury looked a little shell-shocked, mostly because initially the request would have stopped the hearings entirely. But then he ruled from the bench that we could continue on all matters not related. Yeah, I don't think the state would be smart to call her either. At all. At all. Guys, as far as itinerary, because we've got sidebars and we've got Doug's opening statements, and I do think that everybody would enjoy looking at the. You know what? Let's cram it in now. Let's cram it in now. Let's look at the comptroller report. I don't know if I have a handy link for it, but I know I shared it on X, so let me go grab it real quick. Oh my gosh, I didn't include the link in my tweet. Uh-oh. That sucks. Well, I think I shared it in Discord. All right. So here we go. And this is, you can get this on the comptroller.tn.gov. Drop it in the chat. Now, remember, we are going back to 2010. So this is going to be like the climate moving into the time frame of the abduction in this judicial district. So we're going to be looking at the 24th Judicial District, focusing heavily on the Drug Task Force, but there's some other intermingling with the District Attorney General's office. And we're going to be looking at a review of the funds for the year ending June 30th, 2010. This is a mess. This is a mess. Yeah, I was about to finish because we just finished the docket, but we're going to roll right into this audit, this finding. All right, so the comptroller guy was Justin Wilson. The director of this audit was James Arnett. And there's a page with the who's who. All right, okay, just wanted to make sure they're going to tell us who's who. So, all right, our review included an examination of funds administered by the District Attorney General for the year ended June 30th, 2010. In addition, our review included an examination of the Judicial District's Drug Task Force Fund administered by the Task Force Board of Directors for the year ended June 30th, 2010. The review resulted in 12 findings. We reviewed these findings and recommendations with the District Attorney General and representations of the Drug Task Force. Details of these findings, recommendations, and management's response as a result of our review are presented in the findings, recommendations, and financial section of this report. The following are summaries of the findings from our review. The Board of Directors did not assume oversight responsibility. The Drug Task Force had a cash shortage of $5,565 at March 25th, 2011. Officials were unable to locate their policies and procedures manuals. Official pre-numbered receipts were not issued for miscellaneous collections and seized property, so not following the proper protocol for inventory. Some seized funds were not deposited to the bank account or with the county trustee within 3 days of the award. That would be the policy as required. Cash, guns, drugs, jewelry, and equipment under the control of the Drug Task Force were misused, stolen, and or lost. Deficiencies were noted in inventory records. Documentation was not on file to support some purchases charged to Drug Task Force credit cards. The Drug Task Force director falsified an invoice on a construction project. Competitive bids were not solicited for a vehicle and vehicle liability insurance. And this would be you auction stuff off, you can raise more funds, recover more money, and if you don't have anyone bidding, the people that do know about it can get in at a cheaper price below market value. The Drug Task Force director authorized the payment for law enforcement training for the administrative assistant without board approval. The Drug Task Force director did not prepare a list of contraband property for destruction to the court on an annual basis. All right, so let's get into the intro. So they have this letter dated August 16th, 2011. So this is after the abduction where press is getting out about this report. To the members of the General Assembly and of the state of Tennessee and the Honorable Bill Haslam, Governor of the state of Tennessee. Ladies and gentlemen, transmitted herewith is our review of funds administered by the District Attorney General and the Judicial District Drug Task Force for the year ended June 30th, 2010. for the 24th Judicial District of the state of Tennessee. A separate review dated July 11th, 2011 was conducted in each of the judicial districts of the funds administered by the District Attorney General and Judicial Drug Task Forces. However, the results of the review on the 24th Judicial District were omitted from that report due to the subsequent completion of a special investigation. A copy of this report has been forwarded to the District Attorney General of the 31 judicial districts and to various other state and local government officials. Yours truly, Justin Wilson. So, names to know. These are the officials of the District Attorney General's office and the Judicial District Drug Task Force. I think like 3 counties are covered here. So, we're going to be hearing about Hansel McAdams, who we've heard a lot about, District Attorney General during this time period. I think it was, I wrote it down somewhere. He served from 2006 to 2014. Because then remember, Matt Stowe's going to take office September 1st, 2014. So, Sammy Davidson, Hardin County Sheriff. Oh wait, I'm missing stuff. Steve Lee, Judicial District Drug Task Force Director. Tim Cunningham, Interim Judicial District Drug Task Force Director. Leona Simono Longworth. We're going to hear a lot about her and her husband. Judicial District Drug Task Force Administrative Assistant. Then we've also got the Drug Task Force Board of Directors. So Hansel McAdams sits on this board. So he's the District Attorney General and is on the Board of Directors for the Drug Task Force. We've got Sammy Davidson, the Hardin County Sheriff. We've got Roy Wyatt, Decatur County Sheriff. And we've got Monty DeLue, Henry County Sheriff. So introduction. All right, this is a report of our review of funds administered by the District Attorney General and the Drug Task Force for the year that ended June 30th for the 24th Judicial District. A separate review was conducted in each of the 31 judicial districts of the funds administered by the District Attorney General. So they're just saying we didn't only do it here. This is just for the report for this one area. The results of our review of the 24th Judicial District are presented in this report. Background. The 24th Judicial District comprises Benton, Carroll, Decatur, Hardin, and Henry counties. So notice that the Board of Directors doesn't have somebody sitting from Benton or Carroll on the board. They've got the Sheriff for Decatur, Hardin, and Henry on the board. The main office is located in Carroll County, with branch offices located in other counties. The District Attorney General had funds on deposit with the Henry County Trustee, where the District Attorney General resides. The county trustee maintained a District Attorney General Fund and a Drug Task Force Fund. The District Attorney General Fund is used primarily to account for fees received from violating the Fraud and Economic Crimes Prosecution Act of 1984. In addition, this fund accounts for other sources of revenues received by the District Attorney General, such as grants, investment income, miscellaneous refunds, contributions, and other local revenues. The Drug Task Force Fund, which is bigger. We've got more to learn here. Some districts have established multi-jurisdictional drug task forces under the leadership of the District Attorney General. These drug task forces were created by contract, mutual aid agreements, between the participating District Attorney Generals and city and county governments, and were approved by their respective legislative bodies. Each judicial district drug task force, which generally includes sheriffs and police chiefs of participating law enforcement agencies within each district, is governed by a board of directors. Drug task force funds should be deposited with the county trustee in the county of each district attorney general's residence or another county designated by the District Attorney General. The county trustee should credit these funds to the Judicial District Drug Fund. All non-confidential financial operations should be expended through these judicial district drug funds under the administration of the county mayors/executives. The directors of the drug task forces should submit requisitions to the county mayors or executives for goods and services, which would then be obtained through the county's purchasing system. Cash transactions for confidential funds should be requisitioned and dispersed under the supervision of each drug task force director and chairman. All right, so then they're going to go through their basis of the counting. And they run the numbers. Here are some expenditures. Here's their revenues. Here's their ending balance. So at the year ending again, June 30th, 2010, their ending balance was $167,000, most of which was in the drug task force funds. Separate schedules of all funds available and expended for the Judicial District are included in the findings, recommendations, and financial section of the scope. So what was there of the report? So this scope, they did a review of the funds administered by the District Attorney General for the year ended June 30th, 2010. In addition, this review includes an examination of the administration of the Judicial District Drug Task Force funds by the Board of Directors. Our review consisted of tests and records and auditing procedures that we considered necessary in these circumstances. So they're going to say that they have 12 material findings and outline, we reviewed these findings and recommendations with the District Attorney General and representatives of the Drug Task Force to provide an opportunity for their response. They're also going to include their response below in the report. So let's see what we get into. So the findings. 24th Judicial District. Again, we are looking at the funds administered by the District Attorney General and the Drug Task Force. However, due to allegations concerning the Drug Task Force, we extended our review to the Drug Task Force with the assistance of the Tennessee Bureau of Investigation through March 25th, 2011. So they went a little bit beyond this June 30th, 2010. And the reason for this is we're going to see stuff was collected in part of this funding and accounting and inventorying for this year, but then they're looking at what these objects are being used for further down the line. So it's relevant. A review of our findings and recommendations as a result of our review is presented below. Many of the deficiencies noted are the result of management's failure to install internal control procedures and provide adequate oversight. Several of these deficiencies resulted in the theft of cash and property, the questionable use of property seized or owned by the DTF, and, DTF is like from Jersey Shore, right? And an abuse of authority and position. The written responses of the DTF Board of Directors and the Henry County Sheriff are paraphrased in this report. So we've got finding, 10.1. I don't know why they're numbering it this way, but we'll just call it finding 1. The Board of Directors did not assume oversight responsibility. The Board of Directors of the DTF did not assume oversight responsibility for DTF operations. The minutes of the board did not reflect any discussions of the DTF's financial operations, major purchases or acquisitions, personnel policies, controls over evidence and confiscations, and the status of cases. So they're recommending that, hey, the board should meet regularly and approve and review the financial operations, major purchases or acquisitions, personnel policies, and controls over the evidence and confiscation and the status of cases. Like, make sure your people aren't poking around in stuff that sees that could still be evidence for a future prosecution and a pending prosecution. So the management, they're including the response here on this topic. So the Board of Directors agrees with the recommendation. The DTF is under the direction of an interim director, and the board is currently meeting twice a month to review and approve the policies and operations of the DTF. So finding 2, the cash shortage. We have this $5,000, 565 shortage, March 25th, 2011. This cash shortage is composed of $4,065 that we reported in finding 9.01 in the review of funds administered by the District Attorney Generals on June 30th, 2009, plus an additional $1,500 of cash seized in 3 cases the Tennessee Department of Safety awarded to the DTF that we could not trace to the DTF's accounting records or bank deposits. We requested additional information from the DTF related to these cases and the location of the $1,500. However, DTF officials could not locate the funds and had no explanation as to its disposition. As of the date of this review, the $5,565 cash shortage has not been liquidated. So they're going to make their recommendation. They should take steps to liquidate this. The management response says 2 of the seizures were actually awarded in April and November of 2008. So they're saying it's before our time. The board is continuing to research financial records to locate these funds. Additionally, claims will be filed against the surety companies holding the bonds of the employees involved to liquidate these shortages. The $4,065 noted in the previous audit was never turned in or deposited with administrative personnel. At the request of the District Attorney General, these shortages are still under investigation by the TBI. And auditor's rebuttal to the board The auditor says, as noted in our review for the year ended June 30th, 2009, an undercover officer who was formerly with the DTF advised he turned over the $4,000 to DTF administrative personnel. Oh! Oh! So we have a conflict. So somebody's not telling the truth here. All right, finding 3. Officials were unable to locate their policies and procedures manuals. At a minimum, the board of directors should have written guidelines readily available, governing the use of cellular telephones, credit cards, and controls over inventory, seizures, and evidence. Let's see. The board of directors had approved a policies and procedures manual. However, staff was not able to locate this and other records after the administrative assistant was terminated. There had been a manual available for previous audits. The board agrees with the recommendation that it should have one, and is presently adopting new policies and procedures to correct the deficiencies in this audit. Finding 4. Official pre-numbered receipts were not issued for miscellaneous collections and seized. So the DTF did not issue receipts for the miscellaneous collection of funds. This is part of the code. It's required that these pre-number receipts are to be issued for all collections. So this isn't like DTF policy. This is Tennessee code. They've got to issue the stuff. The DTF issued a document entitled Receipt for Property for Items Seized by Agents, Cash, Cars, Guns, and Equipment. However, these receipts for property were not pre-numbered. Sound business practice dictates pre-numbered property receipts for all seized items. And that would mean it would be known if you're skipping something and then not filing it. That's why it's important. So the recommendation is, hey, use these pre-numbered receipts you're supposed to be using. Board of Directors agrees. So, finding 5. Some seized funds were not deposited to the bank account or with the county trustee within 3 days of the award. The DTF did not deposit some seized funds to their bank account or with the county trustee within 3 days of the award by the Tennessee Department of Safety. For example, we noted that some seized cash awarded to the DTF was held for 209 days before being deposited with the county trustee. The Tennessee Code requires officials to deposit all funds within 3 days of collection. They added a few digits here, no big deal. So recommendation, hey, deposit this on time maybe. And response from the management is, oh, we agree. We'll follow the law. Finding 6. This is where it gets juicy. If that wasn't juicy already. Cash, guns, drugs, jewelry, and equipment under the control of the Drug Task Force were misused, stolen, and or lost. Our examination disclosed the following abuse of property under the control of the DTF. DTF Administrative Assistant Leanna Longworth admitted to the TBI that she had removed drug evidence from the DTF office and sold the drugs for her personal benefit. She also admitted to removing and pawning jewelry that had been seized by the DTF. We were unable to determine which cases the drugs and jewelry came from due to poor inventory records. District Attorney General Hansel McAdams advised us and the TBI that he was aware of these incidents. No charges have been filed. And again, this is 2010 spilling into 2011. Edgar Longworth, the administrative assistant's ex-husband, was contracted by DTF Director Steve Lee to construct walls and partitions at the DTF's former office in the city of McKenzie. While performing this work, Mr. Longworth informed us and the TBI that he stole drugs being held as evidence from a burn box. A burn box is a device used to destroy drugs by incineration. Mr. Longworth admitted he sold the stolen drugs for personal gain. Ms. Longworth also admitted to the TBI that Mr. Longworth gave her part of the proceeds from the sale of the stolen drugs. In an interview with us and the TBI, DTF Director Steve Lee advised that he decided to destroy the rest of the drugs being stored in the burn box once he and District Attorney General McAdams had determined the cases associated with that drug evidence had been adjudicated. The drugs were then destroyed based on a court order. Well, that seems different than them deciding to destroy the... So according to Steve Lee, oh yeah, me and General McAdams, we just said, yeah, we're going to finally we're going to incinerate the drugs that are in that burn box. And then the auditors just include this line here. They were destroyed on a court order. Oh my goodness. DTF director Steve Lee stated he did not know exactly what kind of and the number of drugs stolen from the burn box because he did not reconcile the court order of drugs to be destroyed with the drugs in the burn box before their destruction. Do you even try to look like you're not doing something sus? In an interview with us, District Attorney General McAdams stated that DTF Director Steve Lee told him about the stolen drugs, but recommended charges not be filed against Mr. Longworth for the alleged incidents due to a lack of evidence. No charges have been filed. Well, see, the auditor's great. The auditor's not making argument here, but they're giving us all the pieces we need. So, one way that you could have had evidence needed to bring charges against Longworth would be if you reconciled and you said, hey, we have this admission from Longworth that she gained personally from her ex-husband's sale of these drugs that he stole while doing contract work at this office. And then we reconciled against the court order and we said, hey, this is everything that's supposed to be in it, but we only have these things. Thus, these things we could present and say, good reason to believe that that's what was stolen, and then we can bring those charges. So they're not making this argument here, but they're laying out all the pieces there that you can put that together yourself. So the DTF move, and if you guys remember when we looked through the DOJ report for the Fulton County Rice Street Jail, same thing. The way it was written, you know, they're doing an audit. They're issuing their report and their findings and their recommendations. But while they're issuing their report, you know, they have to write it in a certain type of language. They're not going to just go down a side story and do a rant and bant and make arguments. Similar writing style with this. The DTF moved its office from the city of McKenzie to the current site in the town of Henry around August 2010. For several months, the DTF used trustees from the Henry County Jail to assist the DTF in its relocation and to perform various maintenance tasks for the DTF at the new location. District Attorney General McAdams also advised us he initiated a plan for trustees from the Henry County Jail to restore a surplus military Hummer. Oh, this is so 2010. Obtained by the DTF. While performing the various maintenance tasks, the trustees were often left unsupervised in the shop area of the DTF where drug evidence was stored. As a result of the lack of supervision, the inmates gained access to drugs. Oh my god. DTF Director Steve Lee discovered these trustees had compromised some of the drug investigation files, smoked crack cocaine and marijuana, and stole cash, old coins, and other equipment. Officials with the Henry County Sheriff's Department also discovered these trustees had introduced drugs into the facility. Oh, what a surprise! District Attorney General McAdams advised us and the TPI that he was aware of these incidents. No charges have been filed. We don't need periods anymore. No punctuation. We'll just end every finding with no charges have been filed. This is crazy. Oh dear. Oh dear. Just insane. You cannot make this up. And it's interesting because it does feel a little bit like deja vu. I'm obviously thinking over to like Fulton County and all the civil forfeiture issues over there. But, you know, we always like to say when we talk about Fulton County, hey, this isn't the only place it happens. It's just one of the biggest spotlights. Here's a good example. Here's a good example. Somewhere else, same thing. Same thing happening. So we've got, oh, and hold on. We have more greens. And I think we have Chuck Norris in front of many bushes now. Oh my goodness. Guys, thank you again to Sheriff Chuck. We have another 5 gifted memberships. We're also getting some fun pictures. We're going from the green duck bush to the outdoors, the actual forested outdoors. So thank you again, another gifted 5 subs from Sheriff Chuck. If you just turned green, make sure you're saying thank you. And big thank you from me to Sheriff Chuck. Like, tons of gifts. Like, we stopped counting, but we're just going to say he's at like 2 million. So thank you so much. We've got Autry's fake accent says, hey, I had to pop out from the bush to ask this. How does one hunt a plant? The ginseng hunters. Listen, that's an answer I still do not have. Sometimes I call them the ginseng hunter and gatherers just to make it work. But good to see you, Autry's fake accent. Yeah, 2 million. We're not doing accounting here. Sheriff Chuck has donated 2 million gifted subs to the cause. And it's awesome. I think he actually might have taken us up. I think I can add another channel emoji. So there's like thresholds that YouTube puts in the back end. And every threshold you pass, you can add more custom emojis. And I think now we did that. So what was I supposed to add? The Jennifer Nichols backwards. We wanted a Latin term to yell. Did we pick a Latin term that we want to be able to yell with the channel emoji? I could get those together before Monday. So, because Monday I think we'll need a lot of emojis. So thank you again, Sheriff Chuck, making it possible. We've got, all right, we're back to, all right. No charges had been filed. You know, the inmates are just romping and stomping around this DTF office. They're doing the drugs, they're smoking the crack pipes, and they're bringing it back to the jail facilities. No charges filed. DTF Director Steve Lee admitted to us and the TBI that he allowed DTF Administrative Assistant Leanna Longworth to have or to use certain confiscated items. Miss Longworth took home 2 utility trailers that had been confiscated by the DTF. She later bartered one of the trailers for $200 worth of mechanical work on a personal vehicle. She also admitted to the TBI she sold a set of speakers removed from a... Okay, I have the red. I didn't do anything again. I had the StreamYard red thing. So thank you. Where did I leave off? Can you hear me now? Someone say you can hear me now. Okay, it's back. I don't know where I left off. Let's reread this thing about Liana. So DTF Director Steve Lee... I just got the red message again. 1 second. This is so stupid. So I got it. It went right back to a red message, and it's giving me a bubble on StreamYard every time. So, I mean, if it is my microphone, I do have a second microphone. So, but yeah, I don't think it is. I think it's StreamYard. Because that's fun. So, anyway, when I was screaming with it muted, DTF Director Steve Lee admitted to us and the TBI that he delivered a large screen television that had been seized by the DTF to Administrative Assistant Leanna Longworth's home. He swapped the large screen television for a smaller television belonging to Miss Longworth and returned it to the DTF office. Miss Longworth's smaller television was subsequently auctioned off by the DTF. The large screen television was returned to the DTF by the TBI. So I went off. I was like, they're going in and they're bringing back like, oh, I have a smaller TV, but they brought a bigger one in. Let's go and swap this out. And it's just like, they have to be joyriding at this point. Like, whatever comes in, let's just take it because why not? Like, oh my goodness. During the examination of the DTF inventory, the TBI returned a car stereo system found at DTF Director Steve Lee's home. So he's not just giving permission, he's also benefiting, that had been removed by the director's son from confiscated vehicles that were later sold at auction. So now Steve Lee's son is just, we're taking speakers out and then we're selling the car at auction. The TBI also returned a gold bracelet with diamonds and a laptop computer to the DTF that were in the custody of the director's son. It should be noted that the son admitted to the TBI that he took these items from the DTF. District Attorney General McAdams advised us and the TBI that he had occasionally used equipment confiscated by the DTF, such as a Harley-Davidson motorcycle, golf cart, a go-kart, a four-wheeler, and a trailer, and BMW Z3 for personal use. It should be noted that the BMW Z3 was maintained at an airport hangar for limited use by certain other individuals, so you guys can joyride too. We could not determine whether this vehicle was used in the local drug enforcement program as required by Section 53-11-201 from the Tennessee Code, or driven for personal use. Our examination also disclosed that District Attorney General McAdams drives a Cadillac CTS that was seized by and awarded to the DTF. We could not determine whether this vehicle was used in the local drug enforcement program as required by Section 53-11-201 or driven for personal use. While driving the seized vehicle, the district attorney used a DTF gasoline credit card to purchase fuel. During an interview with, and remember, this is Hansel McAdams, so anytime we keep seeing District Attorney General, Hansel McAdams. During an interview with the Henry County Sheriff Montebello, the sheriff admitted to us and the TBI that District Attorney General McAdams allowed him, on occasion, to drive a DTF confiscated vehicle, the BMW Z3. The vehicle was used by the sheriff to attend certain ceremonial events and for personal use. DTF Director Steve Lee gave a 150 horsepower surplus boat motor to a DTF agent. The agent advised us and the TBI that he sold the motor along with his personal boat. However, on April 20th, 2011, Interim DTF Director Tim Cunningham wrote a letter to us stating that the agent had returned the boat motor to the DTF. So something was probably not true. While performing an inventory at the DTF, we noticed 6 cases of file boxes labeled Finished Cases, Hardin County, that apparently had been compromised. Some of the evidence bags that contained cash and drugs had been ripped open and were empty. The 6 boxes of case files were old cases that may have been adjudicated and should have been destroyed. However, due to poor inventory controls, we could not determine if the file boxes had contained items that were stolen or if the evidence had been properly destroyed. We found the following DTF equipment at the Henry County Sheriff's Department: golf cart, a John Deere Gator, a backhoe, and a forklift. It should be noted these assets have been returned to the DTF. DTF Director Steve Lee allowed his son, who was not a DTF employee, to use a DTF vehicle to commute back and forth to work from McKenzie to Jackson, and he also allowed his son to use another DTF vehicle to move personal property from a storage facility. Also, the director allowed his son to have possession of a DTF firearm. It should have been noted these assets have been recovered by the TBI and returned to the DTF. During the course of the investigation, District Attorney General McAdams returned a handgun, 2 assault rifles, 3 heat imaging devices, and a projector to the DTF. The District Attorney General told us and the TBI these items had been maintained at his residence. He further stated the handgun and one of the assault rifles were used for his personal protection. Pulling the old Dinsmore wife story. District Attorney General McAdams disclosed to us and the TBI that he had flown on the DTF airplanes and helicopter on numerous occasions that were not related to official DTF operations. Furthermore, he allowed the Henry County High School administration to use the helicopter to fly dignitaries to football games. DTF officials allowed a local university to use a DTF vehicle. A DTF agent informed us and the TBI that he had seen a DTF vehicle at a local business in McKenzie. Upon further investigation by the TBI, it was determined the vehicle did in fact belong to the DTF. Accompanied by the TBI, we interviewed the business owner, who was the shooting coach for a local university, to ascertain how the DTF vehicle was obtained. The business owner disclosed that District Attorney General McAdams and DTF Director Steve Lee had allowed the local university to use the vehicle for the past 2 years. Shout out to you guys in the chat. Thank you for being good sports about whatever's going on with the microphone. Because sometimes it says the screen audio share, so it's not just the microphone, right? Because I know I moved my desk yesterday, but I've been getting these issues since before yesterday. I don't know. So thank you for being good sports and letting me know. StreamYard's running hot. They're driving around in these confiscated John Deeres and the golf carts, giving us a time. Trial and Error Podcast says, I think joyriding is in section I. Yeah, where we got the mentions of all the vehicles. Yeah, the Cadillac. The Cadillac. Yeah, FFS says, well, if I don't take it, someone else will. Hansel McRambo. Oh, my goodness. Yeah, it sounds like they're all having a good time. It must be nice. It must be nice. So they recommend, hey, management should probably strengthen internal controls over seized property. Seized property should be tagged or recorded in an inventory control system, maybe. Maybe it should be properly safeguarded until the case is disposed. Seized property should not be used by management for their personal benefit or loaned to other individuals. Management should allow only employees of the DTF to use DTF vehicles for official DTF purposes. All equipment and firearms owned by the DTF should be used exclusively for drug enforcement and or drug education purposes, as required by Tennessee Code. So management's response, oh my gosh. We're going letter by letter. So they said that this matter was referred to the TBI for investigation, and the District Attorney General advised auditors he was aware. This is probably addressing the decision not to bring charges. The District Attorney General was made aware of the matter by the TBI 7 days before the audit occurred. Well, that's actually more suspicious. We know this audit's coming, so the employee's employment was terminated by District Attorney General McAdams after being briefed by the TBI. No drug court prosecution was compromised by these thefts. That's their word. That's what they're saying. This matter is under continued investigation by the TBI since Edgar Longworth would not give a statement to DTF Director Steve Lee in 2008. No drug court cases were compromised by these thefts, according to them. The Board of Directors has identified 3 inmates as still serving their original sentences. A violation of probation charge was placed against one inmate due to his admitted involvement in the drug use, and his probation was revoked. So we're revoking their probation because these are the inmates that are romping around in the DTF office, but no one else gets charges? No one else deals with any legal repercussions? Oh, but we did a probation revocation against one. No drug court cases were compromised by these thefts since all drugs involved in these thefts were completed cases. The DTF will no longer use inmate labor for any purpose. Well, okay. There's like so much going on here. And we need the header, the what is happening here header. This matter is being investigated by the TBI. Policies and procedures have been adopted to reflect the auditor recommendations, and they say the same thing from all the way through G. H, these items were not for personal use. However, they were used in events not exclusively drug enforcement or drug prevention related. As explained to auditors, 3 of those items were used in local parade activities in 2007 and 2008 within the 24th District. Vehicles and other items secured at the airport were limited to specific agents and uses. Why were they all being secured at the airport? Vehicles were assigned to, this is addressing the joyriding with the Cadillac. Vehicles were assigned to District Attorney General McAdams to conduct business of the DTF and his office and were used for those purposes. This vehicle, the Cadillac CTS, has been sold and replaced with a state surplus vehicle. The DTF will be issuing state contracted or state surplus vehicles when funding is available, and seized vehicles will be sold. The Board of Directors has adopted policies and procedures to reflect this issue. J. This vehicle, BMW Z3, was authorized for official and ceremonial use by Sheriff Below for 2 days and was returned. So that's just addressing the loan to the individual, not like the like long-term use of this BMW. That's just one rental being explained. The item, 150 horsepower surplus boat motor, has been sold through an online auction. Policy has been adopted to reflect the auditor recommendation. L. Files are being inventoried for destruction. Policies are being reviewed to reflect the auditor recommendation. M. The Henry County Sheriff's Department impound lot was used as an additional storage location for DTF property. Some items were at the Henry County Fairgrounds. DTF staff had properly moved to the impound lot and later to the DTF lot. The TBI was not involved in this property relocation. Yeah, it is interesting to hear how often like fairgrounds are used for like law enforcement usage. This matter is being investigated by the TBI. Policies and procedures have been adopted. Oh, these items were properly checked out by written inventory forms and shown to auditors, with the exception of one assault rifle. All firearms were used in a demonstration program at a Paris Civic Club engagement by District Attorney General McAdams days before the auditor inventory, and this use was explained to auditors. The District Attorney General possesses weapon carry commission authority with drug task forces by state law. Additionally, District Attorney General McAdams possesses a Tennessee state-issued gun carry permit. The District Attorney General will continue to carry these firearms as part of his duties with the DTF and for personal protection. They remain properly assigned to the District Attorney General by written inventory receipts. They did a lot right before this audit. Like, oh, let's hold all of these celebrations. Let's get all of our guns together. Let's get this all together. All right, P, it says all flights were for flight training or government business, though not always exclusive to drug operations. The use by school administration was a joint effort with the Henry County school system for pre-game activities in November 2007, as witnessed by the public, not to fly dignitaries to football games. DTF has participated with 3 other public school systems, all considered our drug education and prevention partners, in events involving the helicopter in 2008 and 2009. So was this used for like a anti-drug awareness thing or something? Why wouldn't they just say that? All right. Q, authority had been granted to a local school entity for a 1-week trip. This is not a private business. DTF's current insurance policy does cover this driver as an insured per the written policy terms. All right. And then management's response. So Henry County Sheriff Monty Bilo says, the Henry County Sheriff's Office never had any proof that drugs were introduced into the correctional facility. We drug tested each inmate, but never found any drugs in or around our facility. But when would you have done the testing compared to the audit? This doesn't even make sense to say that that's a counter argument. Like, anyway. All right, so Monty Bilo says, I use the vehicle, the BMW Z3, as I would any other government-issued vehicle. Well, that inspires confidence. I was in uniform each time I drove the vehicle except for one occasion. I was unaware I could not drive a DTFC's vehicle as a sheriff of Henry County and as a board member of the DTF. I only did it once and I didn't know. We allowed the DTF to use our secured area to store equipment as we do several other agencies. All right, the auditor's rebuttal. So H&I to the joyriding ones. On April 25th, 2011, we interviewed General... So this is This is right after Holly's abduction. So April 25th, 2011, the auditors are interviewing District Attorney General Counsel McAdams. During this interview, General McAdams advises that he use the BMW Z3 for personal use. This included trips to Paris, Cookeville, Savannah, and Nashville. On July 18th, 2011, during a review of these findings and recommendations, General McAdams advised us that he did not use the BMW Z3 or the Cadillac CTS for personal use, but did not necessarily use them for task force-related activity. In addition, General McAdams advised us he felt he had the authority as the 24th Judicial District Attorney General to use these vehicles since he was the district attorney 24 hours a day. We could not determine whether these vehicles were used in the local drug enforcement program as required by Section 53-11-201 or driven for personal use. On March 29, 2011, we interviewed Henry County Sheriff Monty Below. Sheriff Below advised us that the District Attorney General Counsel McAdams allowed him to drive the BMW Z3 on various occasions while it was located at his department. Sheriff Below also advised that on some of these occasions, he used it for personal use. We could not determine whether this vehicle was used in the local drug enforcement program as required by Tennessee Code or driven for personal use. Various DTF equipment was secured at the Henry County Sheriff Department's impound lot. However, the backhoe and forklift were located at the Henry County Fairgrounds, and the golf cart and John Deere Gator were located at a local gun club. These items were moved to the Henry County. This certainly seems like important work. Just driving up my little golf cart, go to the gun club. Definitely doing it for DTF activities. These items were moved to the Henry County Sheriff's Department impound lot when it was discovered that we were performing an inventory of DTF equipment. DTF equipment should be used exclusively for drug enforcement and or drug education purposes as required by Tennessee Code. Oh, they just say, we question the propriety of maintaining 2 assault rifles and 3 heat imaging devices at a personal residence. That's their rebuttal, like, good times. So, yeah, Aaron Heeple, I didn't know I couldn't do that. It was only one time. Destined to Be has no words. Oh my goodness. They need to rename at the evidence storage the swap meet library. Charlie, thanks for the super and the kind words, saying awesome work, Kat. Well, thank you, thank you. I'm enjoying looking through all these filings, though, so, you know, I don't really consider it work. I consider it me screaming at a screen with friends in the audience. But thank you so much for the kind words and the super. Law Kong Express, so was a gun brandished to get a statement? Yeah, the swap meet. That's definitely got to be what it is. Oh my goodness. On April 25th, 2011, so the same interview, we interviewed District Attorney General Counsel McAdams. During this interview, General McAdams advised he flew on the DTF airplanes and helicopter on numerous occasions that were not related to DTF operations. General McAdams advised he allowed Henry County High School administration the use of the helicopter during 4 football games. We confirmed that the DTF helicopter did fly various dignitaries to football games. So it doesn't seem like they're telling the truth even after the audit. DTF equipment should be used exclusively for drug enforcement and or drug education purposes as required by the Tennessee Code. Q, this business owner who coached a local university shooting team was allowed the use of the vehicle to take the team to shooting events. DTF vehicles should be used exclusively for drug enforcement and or drug education purposes as required by Tennessee Code. So now the auditors rebut again. They're rebutting to the sheriff. Okay. So on March 24th, 2011, the TBI interviewed the Henry County Jail Administrator, Captain Steve Page. Captain Page advised the DTF Director Steve Lee went to the Henry County Jail to interview inmates and investigate the incident. Director Lee recovered cocaine that had been brought into the jail along with tattoo guns. So, I mean, I guess it's not really being ascertained here that this recovery was from something that the inmates that were working at the DTF office took and then brought back to the jail. But I'm assuming it's not true that everybody was testing negative for drugs in general. On March 29th, 2011, we interviewed Henry County Sheriff Monty Belo. Sheriff Belo advised auditors that the District Attorney General Hansel McAdams allowed him to drive the BMW Z3 on various occasions while it was located at his department. Sheriff Belo also advised that on some of these occasions, he used it for personal use. We could not determine whether this vehicle was used in the local drug enforcement program as required by code or driven for personal use. Various DTF equipment was secured at the Henry County Sheriff's Department's impound lot. However, the backhoe and forklift were located at the Henry County Fairgrounds, and the golf cart and John Deere Gator were located at a local gun club. These items were moved to the Henry County Sheriff's Department impound lot when it was discovered that we were performing an inventory of DTF equipment. DTF equipment should be used exclusively for drug enforcement and or drug education purposes as required by Section 39-420C of the Tennessee Code. So next finding. That wasn't it. There's more findings. Deficiencies were noted in inventory records. So with confiscated cash, inventory records incorrectly reflected 18 cases that had seized cash totaling $347,355 as being on hand in the DTF vault. They have a whole vault, or deposited in the DTF bank account. However, this cash had been deposited with the Henry County trustee. They've got 5 cases with cash totaling $3,935 were found in the safe at the DTF office. However, these cases were not included in the inventory records. Confiscated drugs. Inventory records reflected 557 cases with seized drugs being held as evidence on hand at the DTF office. However, we were unable to verify this in 297 of the 557 cases. We observed 310 additional cases with seized drugs held as evidence on hand that were not included in the inventory records. Oh my goodness. Bad from both angles. Confiscated vehicles. Inventory records reflected 53 confiscated vehicles on hand. However, we were unable to locate 29 of the vehicles. Inventory records indicate that 6 of the confiscated vehicles were being used by the DTF or the McKenzie Police Department, and 1 confiscated vehicle had been donated to Carroll County for vocational students to use in a mechanics class. We observed 26 additional confiscated vehicles that were not included in the inventory records. Confiscated property. Inventory records reflect 11 items of various types of confiscated property that we were unable to locate. We inventoried 73 additional items of various types of confiscated property that were not included in the inventory records. Confiscated firearms. Inventory records reflected 40 confiscated firearms that should be on hand. However, we were unable to locate 8 of those firearms. Also, we observed 40 additional confiscated firearms that were not included in the inventory records. This is very like, inventory 1, don't inventory 1, inventory 1, don't inventory 1. Of these 40 confiscated firearms, 23 were not tagged to indicate a case number, a litigant's name, or confiscating officer, but were simply stored as evidence in the DTF vault. I think this is extremely problematic for the way we watched the murder weapon evolve in the Holly Bobo case, but what about any of these other cases, or not cases, because some of them aren't tied to anything? This is scary. DTF firearms and other property. Inventory records reflected 4 DTF firearms that we were unable to verify as being on hand. We also inventoried 16 additional firearms that were not included on the DTF inventory. The inventory records reflected only 2 items as DTF property, a 1991 Harley-Davidson motorcycle and a thermal imager located at the Paris Landing Fire Department. The thermal imager was not physically inspected by us, and we were advised the motorcycle was at a repair shop. Well, at least if it's at the fire department, is that something they can use to like find people in a building? Because I'll give them a pass on that one. That's kind of cool. We identified an additional 579 items, and like maybe they should have those in general. Like if that works, if that's something that can be used, like I don't know. I'd imagine it wouldn't help if like a fire's already in a room, but if a fire hasn't gotten to a room yet, maybe you could see that somebody's in a room and you could help them. But I feel like if that's the case, I feel like all fire departments should have that. We identified an additional 579 items that were not found on any of the DTF inventory records. We did not attempt to categorize these additional items to any of the above noted inventory classifications. The 579 items included 2 airplanes. These are not small items. I was thinking like a wad of cash and rubber bands, a packy of drugs. And no, it's 2 airplanes, a helicopter, riding lawnmowers, all-terrain vehicles. Who uses their proceeds? I guess riding lawnmowers were like kind of all the rage, like the luxury gift a couple decades ago. But we got this riding lawnmower with the proceeds of our criminal activity, so we have to seize these items. All-terrain vehicles, televisions, electric welders, farm tractors, federal surplus equipment, and hand tools. So recommendation, hey, maybe we should keep good inventory records. That's important. Management's response. The board of directors agrees that written inventory records are grossly inaccurate. The employee responsible for inventories had her employment terminated. It's all one person's fault. This is all one person's fault. And she's gone now, so problem solved. Nothing else to see here. And some records cannot be found. New DTF employees have worked to remove inaccuracies since receipt of these report findings and inventory. Didn't you say you became aware of some of this like 7 days before the audit? Why weren't you working to fix this since 7 days before the audit? Anyway, all firearms have been accounted for, and additional vehicle records are being sought. The DTF will work with auditor inventories to ascertain correct written inventories in all categories. And it doesn't stop there. There's still more findings. Everyone's like, what? What is happening? What is going on? Header 5. Yeah, I don't know what that would mean. Federal surplus equipment. Also, shout out to Gwennon in the chat. I hope your day is getting better, and I hope you're having a good one. We always love when you're hanging out with us. But yeah, I don't know what this federal surplus would encompass, but I mean, we've already gotten past airplanes and helicopters, so there's that. So, next finding, number 8. We've got documentation was not on file to support some purchases charged to Drug Task Force credit cards. So we've got purchases totaling $8,623 charged to the DTF credit card where there's no documentation on file. These undocumented charges include purchases for supplies, gasoline, lodging, meals, auto parts, and freight. Sound business practices dictate that documentation should be on file to support all purchases charged to credit cards. Recommendation, hey, keep documentation. Management, okay. They're saying that records were in the possession of the former administrative assistant. So the girl that they fired, she was the whole problem. It starts and ends with her. Finding 10, the Drug Task Force director falsified an invoice on a construction project. As mentioned in finding 6B, DTF Director Steve Lee contracted with Edgar Longworth, the ex-husband of Administrative Assistant Leanna Longworth, to construct walls and partitions at the DTF McKenzie office. After the work had been completed, the director created an invoice totaling $720 for payment to Steve Nevels, the son of Miss Longworth, instead of to Mr. Longworth, who actually performed the work. Miss Longworth advised the TBI that DTF Director Steve Lee approved the payment to someone other than the person who performed the work. So did he just not want this on the books or something? Or did they think they couldn't hire him because there'd be like a contract like it looked like they were funneling a contract to a relative, so they put it under someone with a different surname? Anyway, we recommend that you shouldn't falsify invoices. Invoices should be made by the person or vendor performing the service, and disbursement should be made to the individual or vendor that actually performed the contracted work. Management's response, they say, well, this matter is being investigated by the TBI. We're going to adopt policies and procedures. Finding 10, competitive bids were not solicited for a vehicle and vehicle liability insurance. Our examination of the DTF's purchasing procedures revealed the following deficiencies. A, the DTF purchased a new vehicle for $24,066 without soliciting competitive bids. At the time of this purchase, the DTF was operating under the purchasing procedures of Carroll County, Chapter 23, Private Acts of 1975, as amended, which requires sealed bids to be solicited on all purchases in excess of $10,000. So they could have possibly, they purchased it themselves without seeing if they could get a higher market value, fair market value, transparent bidding than this. They kept the number low by not soliciting competitive bids, so it benefits themselves. B, vehicle liability insurance for fiscal years 2009 through 10 for $15,000 and 2010 and 11 for $17,000 was purchased without soliciting competitive bids. At the time of these purchases, the DTF was operating under the purchasing procedures of Henry County, the County Purchasing Law of 1983, and Section 5-14-201 of the Tennessee Code, which provides for purchases exceeding $10,000 to be made after public advertisement and solicitation of competitive bids. So I would think that, consumers are advised, like, call your insurance company, shop around. Even if you've had your provider for a while, call and shop your rates, consider a change, because you'll get bids and you could lower your insurance and or get better coverage. So same thing. Why would, especially if it's policy and we have a county purchasing law and we have Tennessee state code, you should be doing these things, because in the end result would be, it could be a better use, a more efficient use of this funding than to just go all willy-nilly. So, recommendation, the DTF should solicit competitive bids. Now they're going to respond. Management says, hey, this vehicle was purchased pursuant to the state contract from Cardinal Motors of Louisville, Kentucky and Memphis, Tennessee, thus exempt by law from the bidding process. State contract information is available from the State of Tennessee Department of General Services, Motor Vehicle Management Department in Nashville, Tennessee. So they say it's gravy. For B, the board of directors agrees with the finding and recommendation. The insurance policy has been canceled and a new insurance policy obtained under the Tennessee Risk Management Program, a bid-exempt organization under the state bid law. So, what if it was tanks? They had tanks for personal use. Okay, that kind of sounds fun. We have a place near me called Tank America, and I kind of want to try it. You just get to, like, drive the tank. I think you get to, like, fire, like, a machine gun. And I think it'd be cool. Although maybe the machine gun stuff's only at the Orlando location. There's 2 locations. But it's called Tank America, and they've got these big billboards everywhere, and they're kind of getting me with the billboards. So we've got auditor's rebuttal to this. They say the purchasing practices of the DTF for the vehicle purchase were governed by the purchasing procedures of Carroll County, Private Acts, and as amended, which require sealed bids to be solicited on all purchases. They're just repeating it. Carroll County provided us no documentation that this vehicle was ever bid. We contacted the State of Tennessee Department of General Services and determined that the state contract was a state bid for the period October 1st, 2009 through September 30th, 2010. According to the Department of General Services, this contract number could not have been used by the DTF for the July 2009 purchase of the vehicle. Well, very, very funny that only because of this denial, they spill extra tea. They give us a little bit more here in the rebuttal. Finding 11, the Drug Task Force Director authorized the payment for law enforcement training for the administrative assistant without board approval. So Steve Lee authorized a payment of $2,500 from the operational funds to the Law Enforcement Training Academy to pay for the law enforcement training of Administrative Assistant Leanna Longworth. Just her? Just her? Without the approval of the DTF Board of Directors. Ms. Longworth is a non-commissioned law enforcement employee. Recommendation. The DTF Director should seek approval from the board. Management response. The Board of Directors agrees. The employee's employment was terminated and a partial tuition refund was received. Well, you made sure you got your money back for that. Finding 12. Finding 12. The Drug Task Force Director did not prepare a list of contraband property for destruction to the court on an annual basis. DTF Director Steve Lee did not prepare and submit a list of contraband property for destruction to the court on an annual basis. The last order on file was issued by the Decatur County Circuit Court on January 20th, 2009. Tennessee Code requires a list of property proposed to be destroyed at a minimum of once annually. It should be noted that the above-mentioned order was not executed until March 23, 2009, so 2 months later. Recommendation. Hey, maybe keep a list of contraband property for destruction, compile it once a year, and submit it to the court annually. Because that's required. You should be doing that. Also, after orders approved by the court, the contraband property should be destroyed in a timely manner. Management's response. We agree. All right, and then they just go through, they've got a balance sheet, which I think they summarized above. So there's that. Dang. That's actually interesting. Their liabilities and fund balances. This is the total number of what they're actually saying, hey, this is due to litigants, heirs, or others. So we've got some big numbers here for total assets. But what's due to litigants, and this is the district attorney fund, only $60. For the drug task force fund, $7,986 is actually going to someone, a litigant or heir that's entitled to it. So cool. And then a breakdown again of the numbers. Anything interesting here? Got lots of travel. Got lots of rentals. I wonder if there's any bounce house rentals. Got maintenance and repair of vehicles. Let's see, that's a pretty big number. More maintenance and repair of equipment. And I would like to see like records on this. Like, are they actually, is this just how they're running the numbers up? Confidential drug enforcement payments, $20,645. Again, I'm reading from the DTF fund column only. I guess I could just read the total. Clerical personnel was $27,000. Other salaries and wages, $62,000 for expenditures. So how many people do they have doing this? So they're paying $34,000 to confidential drug enforcement people. They're paying more to informants than they're paying out for clerical personnel. Maybe that's why their inventory and record keeping is ass. like maybe divide this up a little bit. Because what do you need? What do you need to keep paying your confidential people if you can't even keep records of what's going on? Because what kind of prosecution is going to result from any of this? That's kind of backwards. Anyway, so this is a little bit interesting. All right, more expenditures. Lots of gas money. Lots of gas money. There's that insurance bill. Law enforcement equipment. Maybe that's the tasers. $29,000. They got a grant. They got a grant here that they put towards salaries and wages. So I guess, we're offsetting some of the costs there. They also have to cover $519 for unemployment insurance. So it doesn't really seem like either they shopped around for that rate or they don't have to pay out that much. What else do we got? looks like transfers of money. And then again, this is how they get to that final fund balance here, 167. So good times, good times. Guys, again, this is from the comptroller website. Dropping the link in the chat here. I'm going to call out the audit. But holy moly, what a time. Yeah, did the drug task force have memberships to Joe's video? Did they tan there? Did they just get video rentals? Did they do it all? FFS says the machine gun is only the Orlando location. Thank you, thank you. Now I cannot put off going there for longer. Yeah, Sheriff Chuck says CIs tell them where all the good stuff is. They don't need to keep track of anything, so why would they need clerical workers? Listen. Aaron says at least they're putting cash with the trustee and not in an account where special prosecutors could be paid out of it. So there we go, you guys. This was the fun time. I kept saying I wanted to read this. And again, this is the climate. That interview that Hansel McAdams, he had to answer for some of this stuff, knowing that this report was going to be published and that people might be like, oh my God, how are you using funds this way? Just showboating around, driving around in Cadillacs and this BMW and helicopters and airplanes. That's all about to be on the horizon while people are looking for answers for Holly Bobo's disappearance. So I think it's actually really important climate context. So I think this was a great read. Tomorrow, again, you guys, we're going to be looking at Doug Bates' opening statements and some of those sidebars. Christy downloaded and grabbed the different transcripts. So we're going to just go through and search for any mention where a conference was held at the bench or parentheses, whatever we can do to jump through the sidebars and get through whatever we can tomorrow. And then Monday, mark your calendars. We're going to be live for like 1,000,000 hours. We're going to be live for like 12 hours on Monday, 12 hours on Tuesday. We're going to see the state present their arguments in this post-conviction relief petition proceeding. We're going to hear from Boat Guy. I don't know what else. But I'm excited to see how it goes. And I'm very excited to see closing arguments, which will probably be Tuesday. So hope you guys can join us tomorrow if you want a extra deep dive. Aaron, this is in no way a direction or a request that you spend your birthday with us tomorrow. But since your birthday is tomorrow, of course, we'll wish you one tomorrow. But if we don't see you tomorrow, here's my wish now. I hope you have an awesome, awesome birthday adventure, Aaron. You deserve it. We have some guy with cancer celebrating today. So maybe you guys can do like a hybrid birthday celebration. So I hope everybody, I love birthdays. So if anyone out there is listening and it's your birthday too, happy birthday to you. But yeah, so that's the game plan though. So other than that, this is what I was going to go live later and do, but we pumped it out now. So I don't think I'll be live again later. I'm going to go, I told you guys at the beginning of the stream, I've got to go and shop vac some stuff out of my washer because it's not draining, and then I got to see if there's a sock stuck in the drain. So I'll report on that tomorrow. I'll let you guys know how that goes, and I will remember to unplug the washer before I do anything. Other than that, thank you guys for all of the help when I was troubleshooting my microphone. Thanks for spending your Saturday with me, and see you maybe tomorrow, maybe Monday, whenever we meet again. Take care, everybody.